wisdom, and your will is good and gracious, and your law is truth. We ask you to guide and bless us in this meeting today so that we might make wise decisions that benefit the people of Texas who we serve. It's in the name of Jesus I pray. Amen.
Oh, there you go. How's that? Roger that. Thanks.
Better.
Carnegie, can you do roll call, please?
Yes, sir. Commissioner Droxrom,
Present.
Commissioner High,
Here.
Commissioner Castaneda, Commissioner Dr. Wesson,
Here.
Commissioner Dr. Callis, Commissioner Chairman Vice Chair Butler,
Here.
Chairman Figueroa.
Here. All right.
We have a quorum.
motion for excuse. For a second. All in favor, say aye. Opposed? All right, motion carries. All right, commissioners, we're going to go to item C, public comment. We're accepting public comments in writing and in person. The commissioners received usually 4, I think, in your packet, and we have 2 additional ones that we've been handed for those. If anyone's here wishing to address the commission on a matter that is not on the agenda, you are here to or contest case or rule. We'll call you up when you get that item on your agenda. If you want to speak, please fill out a public comment form. We're going to do things a little different. Dan will actually call you up 4 at a time, and then we'll just make sure. I'm going to read these instructions to you so as a general guideline. Thank you for being here. Please state your name, who you represent. You'll have 3 minutes, each of you. Please understand the commissioners are not allowed to ask questions or engage in a discussion with you about anything that is not specifically on our agenda. Please also understand that the commissioners cannot hear any information about a pending complaint or enforcement case because we may ultimately be the decision maker in that case. Okay? Go ahead and call the force group first.
Thank you, Chairman. Deanne Renstra, General Counsel. I'm going to call you up 4 at a time. So the first 4 people who are coming up to speak will be Tony Bennett, Kendall Carrillo, Scott Stites, and Ron Whiteup. Thank you, and you'll each have 3 minutes to speak.
Good morning, gentlemen.
And please be sure to say your name and who you represent.
Good morning. My name is Tony Bennett. I'm president of the Texas Association of Manufacturers, and I appreciate the opportunity to submit testimony on behalf of our member companies in support of proposed items to 16 TAC Chapter 73 governing electricians, in particular the Accelerated Journeyman Electrician Education Program known as Jeep. For manufacturers across Texas, this proposal addresses a vital workforce need. Manufacturing remains a cornerstone of the Texas economy, and Texas manufacturing supports roughly 970,000 jobs. Those are direct jobs, contributes more than $338 billion in value to the state's economy, and manufactured exports from Texas reached $293 billion in 2025. We remain the #1 manufacturing state in the U.S. Those numbers reflect the scale of the sector and the importance of keeping industrial projects, facility expansions, and plant operations growing across the state. Manufacturers know firsthand the impact of shortages within the licensed electrical trade. These shortages can delay construction, slow equipment installation, increase costs, and create great uncertainty for maintenance and expansion projects in every region of our state. We appreciate TDLR's effort to create a practical pathway that responds to this shortage while maintaining competency standards and protecting public safety. For manufacturers, this is a competitiveness issue as much as a workforce issue. Texas needs training and licensing pathways that reflect real labor demand and help employers find qualified workers without lowering any standards. TAM supports adoption of the proposed amendments and encourages TDLR to move forward with the Jeep program. And we would also like to thank Courtney Arbor and all the TDLR staff for their work on this very critical issue. Thank you.
Thank you, sir.
Good morning, Chairman and Commissioners. Thank you for allowing me to be here today. My name is Kendall Carrillo, and I serve as the Senior Advisor to the Chancellor at Texas State Technical College. I'm here today because Texas is facing a real and growing shortage in licensed electricians. And as a state agency and trusted Texas industry partner, it is TSTC's responsibility to respond to the workforce needs of the state. I would like to briefly address three primary considerations regarding this program: safety, quality, and the awarding of on-the-job training credits. First, on safety. Safety is a priority at TSTC because we pride ourselves on putting our labs that simulate real life experiences, whether that's climbing a utility pole or operating heavy machinery. We make sure that our students have a structured, supervised, hands-on training environment that allows them to demonstrate skills that are up to industry practices. In this program in particular, we cap the student to instructor ratio at 16:1 to make sure our students have the quality, safe instruction needed. For quality, one of the things we pride ourselves on at TSCC is making sure that our curriculum is industry driven and industry input. Our team of electricians are all journeymen or master electricians, along with our advisory committee, have curated the program and the content. We invite TDLR's Electrical Advisory Board to provide input if we have any gaps that need to be met, the standard for industry standards. This is important because it is all of our goal to make sure that we have safe, qualified electricians. Third, awarding of 3,000 on-the-job training credits. Electricians need time and experience to hone their craft, but not all hours are created equal. We acknowledge nothing replaces real-life experience. However, this program recognizes high-quality supervised training does provide value. However, we also realize that the job's not done once our students finish at TSCC. They are on the pathway to their journeyman electrician's license, but we need employers to actually come hire our students to finish the job. So in closing, this is not about lowering standards. It's about Texas once again leading by example. We have a distinct opportunity to provide our workforce with a complementary pathway that achieves the exact industry standards already established by the trade. I appreciate the consideration. Happy to answer any questions. Thank you.
Good morning. Thank you very much for the opportunity to be here. My name is Scott Stites. I work for Bartlecock General Contractors. We are a Texas general contracting company working in the San Antonio, Austin, Houston, College Station area. We are on the receiving end of the labor shortage in the state of Texas, and especially in the Central Texas area, it is very, very profound. As somebody who has sat for licensing exams, I understand the position that you're in. You protect the health, safety, and welfare of the state citizens of Texas. That's why we have licensing. As somebody who sat in these exams, the farther you are from the classroom, the less likely you are to pass that test. You no longer carry on the rigor that you had in the classroom, and not passing that test, and we have a failure rate of 70% in the state of Texas, which speaks to the rigor of the exam, but it also probably suppresses further pursuit of that registration. And also, once you get that license, you're now on the continuing education track. So we have the ability, by closing that failure or success gap, to maintain a skilled workforce that's going to be young, which is going to benefit their families through higher paychecks and benefit all of us collectively by having better access to qualified workers. I believe, in speaking to our trade partners in the electrical world, there is concern with rigor. That making sure that we're not, matriculating people out that, from diploma mills. I think our partners at TSTC, community college, IEC shops, and the unions are all pulling on the same rope with respect to that level of success that we need. And I think by bringing that opportunity to sit for the exam a little closer to those students' reality when they're young, you have the ability to get more alignment across those programs with more consistent products for those candidates. Thank you for your time.
Good morning, Mr. Chairman and Commissioners. My name is Ron Woodup, and I've worked in the electrical power testing, maintenance, and worker safety industry for more than 40 years. I'm a state of Texas journeyman electrician, and I serve in leadership roles with the NFPA, IEEE, and NETA technical committees. I currently serve as the chairman of NFPA 790 and 791 for field evaluations of electrical equipment and I participate in the National Electric Code Panel 11, and also I serve as a committee member of NFPA 70E, Standard for Electrical Safety in the Workplace, and NFPA 70B, Standard for Electrical Equipment Maintenance. Through those roles and through hiring of electrical workers across Texas for many years, I understand firsthand the growing need for qualified, properly trained electrical workers. I'm here today in support of the proposed rule change for the Jeep program and the partnership with Texas State Technical College. Texas is experiencing unprecedented growth in electrical infrastructure, industrial expansion, data centers, manufacturing, and power system investment. The challenge all of us face is the same: finding enough skilled electrical workers and preparing them to work safely and productively in the field. This proposal helps address that challenge in a practical and responsible way. TSTC has a long track record of producing graduates who enter the workforce with foundational technical skills and understanding of electrical hazards and the discipline needed to continue learning safely on the job. I know this personally because I'm a 1982 graduate of TSTC. I have an associate's degree from there. And throughout my careers, I've hired many TSTC graduates, including 15 spring graduates that just started last week with my company, Vector Power, in Plano, Texas. There's a noticeable difference in individuals who have completed that educational process. They arrive better prepared, more safety conscious, and more ready to contribute to Texas employers and infrastructure projects. You know, we're in a labor-constrained market. Unlike anything we've ever seen before, meeting the demand safely will require collaboration between industry, education, and the state. I believe this proposal is a smart step forward to workforce development, worker safety, and the future reliability of Texas electrical infrastructure, and I respectfully encourage the Commission to vote in the affirmative. And I'll leave you with this one final thought. The proposal for Jeep does not reduce standards. It strengthens the pipeline of qualified individuals entering the profession through structured education and accountability. We have seen similar success with the plumber program here in Texas, and I believe we will see similar success with electricians. Thank you.
Thank you, gentlemen. You can go ahead and call the next board, please.
The next group will be Mia McCord, Jeffrey Taha, thank you, Dave Wilson, and Dominic Padilla. Again, you'll each have 3 minutes.
Good morning.
Good morning.
Go ahead.
Thank you, Chair Figueroa and Commissioners. My name is Mia McCord, and I'm Vice President of Government Affairs for the Texas Chemistry Council. I appreciate the opportunity to present testimony in support of the proposed amendments to the Accelerated Journeyman Electrician Education Program, or JEEP. We appreciate Director Arbor and the TDLR staff for their thoughtful work in developing this program. TCC represents 60 member companies who own and operate over 200 manufacturing and research facilities across the state. The petrochemical industry is a key driver of economic activity, providing essential materials for consumers and manufacturers. Texas leads the nation in petrochemical manufacturing, supporting over 500,000 direct and indirect jobs, contributing billions to the state's GDP, and exporting over $50 billion in products annually to customers around the world. The business of chemistry depends on a strong and qualified workforce, including licensed journeyman electricians. Without these professionals, our industry cannot grow and cannot safely operate. Our facilities are highly complex and safety critical environments. Every unit of production, every pump, every compressor, every control system depends on the work of skilled licensed electricians. For our members, the lack of licensed journeyman electricians is a tangible issue. It delays plan improvements and expansions, drives up capital project costs, and creates real operational risk. It threatens Texas' ability to attract new investment and build the next generation of facilities that will sustain economic growth for decades to come. Texas is in a race for investment against other states and other nations. When a global chemical company is deciding where to site a multi-billion-dollar facility, workforce availability is one of the top factors in that decision. Right now, workforce shortages in the licensed electrical trades are a real competitive liability for Texas. The Jeep program offers a responsible, structured solution. It maintains exam and competency requirements. It preserves the on-the-job training standards, and it creates a meaningful, accelerated pathway to grow the pipeline of licensed journeyman electricians that Texas industry urgently needs without compromising the safety standards that protect workers and the public. The Texas Chemistry Council strongly urges the Commission to adopt these amendments. Thank you.
Thank you.
Chairman Figueroa and Commissioners, thank you for the opportunity to speak today. My name is Dominic Padilla, and I serve as the Vice President of Corporate Strategy for White Construction here in Central Texas. I'm here in support of the proposed amendments to 16 TAC Chapter 73, establishing the Accredited Accelerated Journeyman Electrician Education Program, or JEEP. From where I sit in commercial construction, the shortage of skilled electricians is one of the biggest constraints facing growth in Texas right now. In Central Texas alone, we're seeing massive demand tied to data centers, manufacturing, healthcare, schools, and infrastructure, but there simply are not enough electricians entering the field fast enough to keep pace. And I believe part of the problem is that the current licensing structure is based on an outdated model. Historically, the system was designed around the idea that knowledge would slowly develop over years in the field before someone ever sat for an exam. But today, training looks very different. Candidates are receiving intensive classroom instruction, hands-on lab training, and highly structured technical education much earlier in the process. Yet, we still require many of them to wait years before taking the exam. That gap matters. Because when education and testing become disconnected, knowledge fades. And what we end up measuring is not necessarily competency, but retention over time. I can personally relate to that. Right now, I'm preparing for the GB98 General Contracting License exam in New Mexico. I have a 4-year degree in commercial construction and decades of experience in this industry, but much of the technical material I'm studying has not been part of my daily work for years. So I've spent a tremendous amount of time relearning information I once already knew. Not because the education failed, not because the standards were wrong, but because too much time passed between instruction and examination. That's why I believe those will make sense. The Jeep program does not lower standards. Candidates still take the same exam and still complete substantial supervised experience requirements. What it does is modernize the sequencing. It allows candidates to test while the material is still fresh, while competency is highest, and while the momentum is still there. That creates a strong pipeline of qualified electricians at a time when Texas urgently needs them. From both a workforce and business perspective, I believe this is a smart, practical reform, and I respectfully encourage your support. Thank you for your time.
Thank you. Yes, sir.
My name's Dave Wilson. I've spent 50 years in the electrical trade as an apprentice, journeyman, master electrician, contractor, student, and teacher. And I also have sat on the National Code Panel. For the past 24 years, I've operated the Texas Electrical Safety Association, a nonprofit that provides NFPA 70E safety training, continuing education, exam preparation, and we have a 4-year apprenticeship program approved by the Department of Labor and the state of Texas. I'm here today to stress the importance of maintaining strong standards for electrical licensing and training, and ask that this board not reduce on-the-job training hours. The National Electrical Code does not require a worker to hold a license or pass an exam to do electrical work. It requires a qualified person, which the definition is one that has skills, knowledge, and safety training to perform the work safely and recognize hazards. Those qualifications cannot come from the classroom alone. Real competency is built through hands-on, on-the-job experience. Classroom training provides knowledge, but on-the-job training develops judgment and skill. Nearly every skilled profession recognizes this. Doctors, for example, complete years of residency before practicing independently. Lowering standards, especially reducing on-the-job training requirements, addresses a temporary workforce shortage would be a huge mistake. It risks weakening public safety and the integrity of the profession. Instead, the board should consider practical alternatives, such as a special journeyman's license for apprentice with 8 years of documented field experience and no test required. Similar systems existed in Texas before the 1990s without causing manpower shortages or increasing safety issues. This could solve the manpower shortage immediately. Today's proposed rule change, contrary to what you've heard, will indeed lower on-the-job training hours from 8,000 to 5,000 hours. The goal of this board should be to expand the workforce without sacrificing competency, safety, or public trust. Thank you for your time and consideration, and I defer to the wisdom of this board.
Thank you. Yes, sir.
Good morning, Chairman Figueroa and members of the commission. My name is Jeffrey Tawawa, and I serve as president of the Associated Builders and Contractors of Texas. And on behalf of our over 1,700 member companies and the 98% of the Texas construction workforce that chooses to not be part of a union, I'm here to express our strong support for the proposed amendments to Chapter 73 and the creation of the Accelerated Journeyman Electrical Education Program, or JEEP. Texas is growing at an incredible pace, and demand for the skilled electricians has never been greater. Across the state, our contractors are struggling to find enough qualified workers to keep up with the projects needed to support that growth, whether that is schools, hospitals, manufacturing facilities, energy projects, infrastructure, or commercial development. We believe programs like JEEP are an important part of the solution. Importantly, we do not believe expanding this pathway requires sacrificing safety or quality within the electrical profession. You will likely hear arguments suggesting otherwise, but the reality is that high-quality training and strong safety cultures are not limited to one model or one organization. At ABC, our members invest heavily in workforce development, apprenticeship, and safety training, and our chapters operate training centers across the state focused on developing the next generation of skilled craft professionals. In fact, ABC top performer contractors are nearly 7 times safer than the industry average based on OSHA incident rates. That does not happen by accident. It happens because contractors are committed to rigorous training, accountability, and ensuring workers are prepared before stepping onto the job site. And with the industry estimates showing that the nation will need roughly 456,000 additional construction workers to meet demand, we need every viable opportunity and pathway available to close that workforce gap while maintaining those same high standards of safety and quality. Programs like JEEP recognize the value of structured hands-on education tied directly to real-world industry needs. These students are not bypassing training requirements. They are receiving intensive instruction designed to prepare them for successful careers in the electrical industry while completing substantial supervised experience before licensure. This proposal is about creating opportunities for Texans to enter the high-demand profession, strengthening our workforce pipeline, and ensuring Texas has enough skilled electricians to meet the needs of our growing economy. We appreciate the department's leadership on this issue and respectfully encourage adoption of the rule change. Thank you for your time and consideration.
Thank you. Thank you so much. Ian? Okay.
One more, and that is Francis Blake.
Pick a chair, any chair. Good morning.
Good morning.
Go ahead.
Morning, Chair, Commissioners. Thank you. My name is Frances Blake. I'm the General Counsel and Vice President of Regulatory Affairs for the Texas Association of Builders. The Texas Association of Builders has nearly 10,000 members, home builders, residential home builders mainly, electricians, plumbers, and TAB is here today to support the JEEP program. As you've heard today from previous testimony, this program is a necessary step to address the shortage of electricians in our state. few statistics from the residential construction side. In Texas last year, nearly 150,000 new homes were built, and that is going to continue to increase over the years. The United States Bureau of Labor and Statistics says that we need 80,000 new electricians a year through the year 2033. So that is going to be a huge amount to make up that gap every year. So TAB strongly supports this program. Additionally, TAB, as written, it requires 3,000 hours that's the maximum amount of hours that can be credited in the proposed rule. TAB would respectfully request that when you consider this, you consider increasing that to 4,000 hours. And that's because, as you heard earlier from TSTC, the training program it's truly wonderful and remarkable. And you really do get on, very, very close to on the job training at places like TSTC. So in conclusion, thank you for your time. Thank you for the time today. And we respectfully request that you adopt this rule. Thank you.
Thank you so much.
Thank you.
Ms. Blake.
Chairman, is there anybody else who did not sign up who is here to speak on behalf of an item, public comment? Okay, I think that's
Any other
it.
comment? Honor,
No more
any other
comments.
issues? That's it? Okay.
That's it.
All right, Commissioners, we're going to go to executive session as a consult with our attorney under section 551.071, subsection 1, 551.071, subsection 2, and 551.074 in the government code. The time is 8:58. Dan, how long do we think you'll need? 30 minutes? 45 minutes. So we'll do executive session. We'll take a break and we'll come back here at 8:45. I'm sorry, 9:45. Check that. 9:45. And pick up with any action items from the executive session items to begin our the contested cases. Time is 9:52. And we're going to call back into session. We do have an action items that we want to discuss from the executive session. I'm going to recognize Vice Chair Butler.
Thank you, Mr. Chair. Want to do strategic planning first?
No.
Is that what we're doing?
No. This is the review.
Oh, okay. Okay. Thank you. Thank you, Mr. Chair.
Maybe I won't recognize you. Maybe I won't recognize.
As part of assessing the executive director's work for the commission for the last couple of years, we convened a HR work group to discuss metrics and rubrics as to how we judge her performance and how she's done over the last 2 years, and then set some goals for the future. And so what I'd like to let the agency and the public know is that we are extremely blessed and happy to have Courtney here as executive director. Over the last several months, we've assessed her as a commission, and I think unequivocally I can say that her performance for the TDLR and the taxpayers of the state of Texas is exemplary, with all the challenges that she walked into, and then the tasks that she's been given by the legislature, and unfortunately by the 7 commissioners sometimes has got to be a challenge. But she has surpassed those challenges. I've mentioned to her that some people are smaller than the job they're given, and some people are bigger than the job they've given. She has comported herself very well with the goals of this agency, and still has a sunny disposition and a cheerful manner to deal with the employees and the commissioners and all the people who are constantly asking for something of her, right? And she's pulled in so many different directions, and we see that, and we know it. And so I just want to say, Courtney, thank you so much for your leadership in this agency. I look forward to seeing your legacy here. It's going to be a tremendous legacy with all that you've been given. And you are well suited for this job. And I thank you for taking on this role. That's it, Mr.
Okay.
Chairman.
All right. I'll take a motion to approve the performance report. Is there a second? All in favor, say aye.
Aye.
All opposed? Motion carries. Congratulations, Ms. Harper. Good job. Commissioners, we're going to go to item F, but we're going to skip that for the July meeting, right, Deanne?
Correct.
Okay. Yeah, we'll table it for the July meeting. And then, so we're going to move to contested cases. If anyone is appearing in person for the case today, we'll call you up when your case is announced. We'll hear from the prosecutor first, then we'll hear from you. You'll have an opportunity to speak. Make sure you speak clearly and say your name and who you represent. Each side will have 5 minutes to speak, with up to 3 minutes for rebuttal if needed. Please understand that the commissioners can only consider information that is in the record from when the case was heard at SOA. So you must limit your comments to those matters that were presented at the SOA hearing. All right? Oh yeah, we got that. And so we're going to go with G. We're going to go first one, which is Adrien Lomos, and Stuart Baggish will be the prosecutor.
Chairman, there is somebody here to represent, no. Yeah, Adrien Lomos, I believe, is here.
Oh, okay, Mr. Lomos, go
Okay.
ahead. Yeah, come on up
Come
and
on.
have a seat. Do you have counsel with you, or is it just you? Okay, okay. Do you understand what the instructions that I read earlier?
Yes.
Okay, perfect. Thank you, Mr. Lomos. All right, Mr. Baggish, go ahead.
Good morning, Chairman and Commissioners. My name is Stuart Baggish, and I am a prosecutor with the Enforcement Division, and I'm here to address the first contested case on today's agenda, which is Respondent Adrien Lomos. The proposal for decision that the State Office of Administrative Hearings issued in this case provides for a $6,250 fine, a 1-year full suspension of respondent's electrician's license, and an order that respondent make a refund to complainant in the amount of $51,529. The violations that the PFD finds respondent committed are engaging in dishonesty, misrepresentation, or fraud while performing as a licensee, which is a Class C violation punishable by a fine between $2,000 to $5,000 plus a 1-year probated suspension up to revocation, and failure to include necessary language in a proposal contract or invoice, which is a Class A violation punishable by a fine between $500 and $2,000. I ask that the Commission adopt the PFD with a minor modification to increase the refund amount to $54,729. This is an electrician's case in which complainant is a Terrell, Texas, Kaufman County property owner who hired respondent as a master electrician for complete new construction electrical installation. Complainant and respondent had a contract which complainant fulfilled, paying respondent $54,729, in return for which respondent installed only about $3,200 worth of work before halting progress on complainant's project, and instead used the job site to store materials that respondent never installed for complainant's job, though he left complainant's site with some of the materials. Complainant ended up having to hire a third-party replacement master electrician to finish the work, which started with removing everything respondent had installed because it was done improperly. It ended up costing complainant more than $100,000 for the replacement master electrician's labor and materials. After complainant paid respondent, she tried communicating with him, but he never responded. Complainant reported respondent to the police for grand theft and fraud, but it was not prosecuted to resolution in criminal court. Complainant also filed a complaint with TDLR in 2023 seeking administrative relief, which is the case that brings us here today. On March 30, 2025, while the case was pending administrative enforcement, respondent filed a Chapter 7 petition in bankruptcy court, which is a liquidation bankruptcy, which complicates things for complainant. Because the first count in the PFD is a fraud violation, there's a question whether bankruptcy discharge is available to respondent for his debt to complainant. The bankruptcy petition merely adds to the considerable inconvenience complainant has experienced in her dealings with respondent. In sum, notwithstanding the PFD, I request that the Commission find as follows. 1. Respondent's violations in this case constitute fraud, misrepresentation, dishonesty, and untruthfulness against complainant. 2. Respondent be assessed an administrative penalty of $6,250. 3. Respondent be ordered to refund $54,729 to complainant. And 4. Respondent receive a full 1-year suspension of his electrician's license. Thank you. I am prepared to answer any questions you may have.
Any questions, Commissioners? Okay. Mr. Lomos?
How you doing? I'm Adrien Lomos. I'm here regarding my master's license 466333. I respectfully ask TDLR to allow me to keep my license and continue working in the trade that I have built my life around. The license is extremely important to me. I'm a single father of 2 girls. This is how I make my living. My license is how I provide for my children, pay my bills, support my family, and continue building a future for them. Losing this license will not only affect me professionally, it would directly affect me by my ability to provide for my daughters. I fully understand holding the master license is serious responsibility. A license is not just a title. It means that I am responsible for safety, electrical work, proper permitting, compliance with rules, and protecting the public. I do not take that lightly. I understand the electrical work can affect home, businesses, contractors, employees, customers, and the public. I have worked hard to carry that responsibility the right way. Through Mad Electric alone, I have permitted and worked on 103 projects throughout Texas. Just with RTA groups, I have worked on 24 projects. These these were completed across different areas with different customers, contractors, property owners, and inspectors, and job requirements. My work history shows that I have been active, responsible, and productive in the electrical industry. I have worked with many people and many contractors. I have completed dozens of projects without any issues. My overall contribution has been strong, positive, and meaningful. I have worked hard to build RTA groups up to where it's at today, which is in the top 10% of the electrical contractors. That did not happen by accident. It happened through hard work, dedication, long hours, responsibilities, and commitment to doing the job correctly. I respectfully ask for department to consider full picture who I am and what I've done. The situation appears to involve one complainant from one person. I understand that one complainant must be taken seriously. I'm not asking TLR to ignore consideration. I'm asking for the one complainant not to be allowed to define my entire career, my character, or my ability to safety and responsibility to hold a license. I also respectfully state that I disputed the statements made against me. I believe some of them were not accurate, and I did not fully speak on them at the time because I didn't want to make the matters worse, turning them into a personal argument. Looking back, I understand that I should have spoken more clearly and provided my side with supporting facts, which I have. Today, I respectfully ask for the opportunity to be judged based on evidence, my full work history, and the proof that I have been a responsible contractor. I also would like the department to consider that my issue involving LPI contractors is currently in the process of expunction because of the matter has been handled separately and is process of being cleared. I respectfully ask that it is not treated as final negative mark against my license or my character. I'm prepared to provide documents showing the current status of the matter, which I have here. Since having my license, I haven't had any criminal record. I've continued working, supporting my family, completing projects, trying to do things the right way. I believe that my history shows that I'm not in danger to the public, and I can continue to be trusted as a responsible license holder. I also want to respectfully address the comments made by Mr. Baggett during the hearing. Some of the comments made while I was speaking felt controversial, did not reflect the actual facts of my work history and proof I have. I believe those comments contradict the broader view of many customers, contractors, and people I have worked with successfully. I respectfully ask that the department rely on factual material, documented work, permits, my project history, my overall record, rather than opinions or statements that are not supported by evidence. I have proof that I am a responsible and capable contractor. I have proof of my permitted projects, my completed work, my business activity, and the fact that I continue contributing to the electrical industry throughout Texas. My record shows that I have worked hard, taken responsibility, and completed a large number of projects without this type of issues being claimed in this matter. I respect TLR's job. I understand the department must protect public and enforce rules.
Mr. Lomas, your time is up.
Okay.
Thank you, Mr. Lomos.
Yes, sir.
Questions, Commissioner?
I have questions, Chair. Mr. Lomos,
Yes.
in 2021, you were given the contract for 125,000. That's what the records show. Okay. Then there was a change order for about 26,000.
Mhm.
That means it's close to 150,000. The ALJ recommends return of approximately 30% or something. So you look at this way, you claiming that you're responsible or something, whatever the facts of the matter, the cases,
Mhm.
you could have given the money back and walked out amicably, but you choose to go through this and put the business into issues because of lack of your performance right there. They paid you. How do you think the public are going to trust us when people like you who sign a contract and walk out and now I hear bankruptcy? So this is kind of a responsible electrician. You can disagree, pay, walk out, but you choose the other way to take all the money and run. Now explain me why that your performance should be looked into because that's not an issue right here. It's you're deceived.
Right. So those 50,000, 20 something thousand of them went to just equipment by itself. Um, Also got proof that I paid subcontractors to complete building 3 and did all the underground on it. So all that money went into the contract itself. I didn't have anything to run with. I didn't steal nothing. There was no money left after I paid all the bills from that specific contract, which I have proof of. The only reason why I went into bankruptcy is because I didn't have any more money. I was losing everything, and then I was put into a problem that wasn't my problem. Put me on the news, and that forced me to literally get fired from every job that I went to. So that I didn't have anything to go to or run to. I didn't run. I didn't hide. I just, they just, TDLR just called me specifically and said, "Hey, give her back the 50,000." I mean, there's nothing to give back if everything was in the contract, in the project.
Thank you, Mr. Lomos. Any other questions? All right, Vice Chair Butler.
I appreciate you coming here and facing the music. I was a little concerned. Your statement just mentioned you and the struggles that you've had and the problems that you've had and the great job that you've done while you're an electrician, but you barely mentioned the complainant in this, and I think that's an important factor. And it causes me some concern if you were to continue to practice. There are unsuspecting members of the public that would just hire you and expect the work to be done without knowing your history. Um, so I would ask you to reflect on that. It's not about you, buddy. This license protects the unsuspecting members of the public against people like you. Okay? It's never about you. It's about them. And I think you've lost the plot there. And that causes me some great concern.
Any other comments, questions? Okay, I'll take a motion, Commissioners.
Chair, I move to adopt the PFD with a correction to the finding of fact number 2, which reflects the complainant's name.
Is there a second to that?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. All right, Mr. Lomos, someone on the staff will follow up with you if you want to
Okay.
further this journey, okay?
Okay.
Thank you. Commissioners, item number 2, Daniel Cantu and Cassandra Maggie. Courtney, can y'all hear me on this? Is this close enough? Okay, good. Go ahead, Ms. Maggie.
Good morning, Chairman and Commissioners. My name is Cassandra McGee, and I am a prosecutor with the Enforcement Division. We recommend that you accept the Administrative Law Judge's proposal for a decision rendered on February 6, 2026 in this case. On March 19, 2025, an inspection was held at Goodfellows Barber Shop, and the inspector found 2 direct-to-enforcement violations. The department alleged that the respondent, Mr. Daniel Cantu, failed to properly clean and disinfect non-single-use implements and tools, including clippers, razors, and combs, after each client, and that he also employed or leased space to an unlicensed individual to practice barbering services in Mr. Cantu's licensed establishment. In the proposal for a decision, the ALJ found the following. Workstation 6 at Goodfellows had several combs, clippers, and towels that contained hair and debris buildup. Workstation 6 at Goodfellows had razor blades that were not disinfected. Mr. Cantu admitted the condition of Workstation 6 was unsanitary. The ALJ further found evidence that Mr. Cantu had allowed Mr. Raul Roman to continue working various periods of times at Goodfellows while Mr. Roman was unlicensed. Mr. Cantu allowed Mr. Roman to work at Goodfellows after an inspection on July 10, 2024 until November 2024. Mr. Roman was unlicensed when he worked at Goodfellows from that July 2024 to November 2024 timeframe. The department offered evidence of the July 10th, 2024 inspection, conducted by the same inspector who conducted the March 19th, 2025 inspection, where workstation 6 was attributed to Mr. Roman on both inspection dates, and Mr. Cantu admitted to employing Mr. Roman. On June 3rd, 2025, staff sent a notice of alleged violation to Mr. Cantu proposing a $4,000 administrative penalty. On February 6, 2026, the ALJ recommended a $2,000 administrative penalty against Mr. Cantu for each violation under TDLR's enforcement plan, totaling a $4,000 administrative penalty. On February 11, 2026, the department filed exceptions to the proposal for decision correcting the violation from Class B to Class C from the department's enforcement plan and correcting the spelling of my last name. On February 23rd of 2026, the ALJ issued a ruling granting these exceptions. The department recommends that you accept the proposal for decision, including the special exceptions, and impose a penalty of $4,000 against the respondent, Mr. Daniel Cantu. And I am available to answer any questions.
Thank you. Questions, commissioners?
Chair, I have a couple of questions. Council, if I understand, because not cleaning, the fine is from 1,000 to 3,500. So the ALJ gave $2,000 fine, correct, on charge number one?
Correct.
And the second one, because a licensee holding, the license, and he employed someone without a license. So that's Class C is up to 2,000 to 5,000. Is that fair?
Correct.
Chair and commissioners, I think, someone who is licensed ought to be more responsible. And I think, one is a health hazard, which is not cleaning, and also employing someone who is unlicensed. I think that's a serious offense, and, we need to put the maximum fine so that people don't do that one. So I would probably recommend 5,000, but leave the 2,000 right there so that things like this don't happen again.
Okay. Any other comments? Okay. If you want to make a motion, Commissioner Dr. Ramos, fine, with the amendment.
Yes, I move to accept the ALJ, the PFD, with increasing the fine amount from 2,000 plus 2,000 to 2,000 plus 5,000, which is basically $7,000.
Is that accurate, Deanne? Check with that math, just to make sure.
I'm an engineer, sir.
I don't.
That would be amending conclusion of law number 11 to $5,000. Is that what you're looking to do? Okay.
Yeah,
Okay.
increase that. Okay, all right. So there's a motion. Is there a second? Second? All those in favor say aye.
Aye.
Opposed? All right, motion carries. Thank you. Thank you.
Thank you, Commissioner.
Commissioners, to item 3, Avery Crawford, Natalie Olvera.
We have, is it Louis Martinez?
Yes, it is.
On behalf of Mr. Crawford.
Okay. Mr. Martinez, Mr. Avery, you understand the rules that I read earlier?
We do.
Yes. Perfect. Okay. Go ahead, Ms.
Good morning, Chairman and Commissioners. My name is Natalie Olvera. I'm a senior prosecutor in the Enforcement Division. The ALJ recommends you deny respondents Avery S. Crawford's Class A barber's license application and revoke respondent's current Class A barber license based on respondent's criminal history, unfitness to hold the license, and material misrepresentation to the department. I ask you adopt the PFD as written. In 2023, respondent was placed on deferred adjudication for felony injury to a child with intentional bodily injury. Respondent was placed on community supervision for a period of 5 years to terminate on or about in August of 2028. Included in the police report and/or in the indictment for the criminal offense, respondent was accused of having sexual contact with a child less than 14 years old. Specifically, it alleged the child performed oral sex on respondent and respondent's penis penetrated the child's anus and vagina. Additionally, it alleged while the child was currently in middle school, respondent had been abusing the child since they were in 2nd grade. On respondent's criminal history questionnaire, respondent stated there was insufficient evidence for his criminal offense, even though he was placed on deferred adjudication for that offense. Furthermore, when respondent asked why he lied on his renewal application and said he didn't have any recent criminal history, he said he was found not guilty and the accusation didn't reflect who he was. Respondent testified he filled out his CHQ form himself and was originally charged with sexual abuse of a child, but pled to a lesser offense because he was faced with the possibility of going to trial and didn't want to take any chances of going to prison. Respondent maintained he was not guilty of the criminal offense. Respondent also testified he performs barbering services on all ages of clients. Evidence from the criminal trial was not offered nor admitted into this administrative hearing. Respondent did not submit any rehabilitation or rehabilitative efforts to the department, such as completed class certifications. Respondent's offense is a guideline crime for barbers because the offense involved prohibited sexual conduct and involved a child as a victim. Barbers have direct contact with the members of the public, often in settings with no one else present. Respondent was about 34 years old when placed on deferred adjudication. A Class A barber's license comes with no restrictions placed on it. A licensee can practice in any array of settings and on all ages. There are no restricted licenses available in barbering profession. The department does not have the authority to agree to any restrictions placed on the license. Additionally, there are no mechanisms in place to monitor compliance with restrictions. Again, due to respondent's criminal history, unfitness to hold the license, and material misrepresentation to the department, I ask the proposal for decision be adopted as written. I'm available to answer any questions. Thank you.
Thank you. Any questions? Okay. Martinez.
Yes, sir. Mr. Chairman, members of this commission. My name is Luis Martinez. I'm here on behalf of Mr. Crawford. What I'd like to make known to this commission is Mr. Crawford himself filled out his questionnaire. I don't think that he appreciated, due to his level of sophistication, the fact that his deferred adjudication had to be reported, given that it was not a conviction, and that he essentially had not been found guilty of any crime. The offenses that were made against him were very, very serious in nature, obviously. Those offenses were based on accusations and accusations alone. There was no physical evidence to back that up. There were no witnesses, no video evidence, nothing other than the accusations of a child who was the child of his ex-girlfriend. Those accusations were made subsequent to a very messy breakup. In fact, the woman herself accused Mr. Crawford of assaulting her. Those charges were dropped in their entirety. Given the serious nature of those accusations, the DA's office in Bexar County sought an indictment. But when the evidence in that case began to fall apart, Mr. Crawford was offered both deferred adjudication, which, as this commission knows, does not carry a final conviction with it, and was offered a chance to be placed on deferred adjudication for an offense that was not sexual in nature and did not require sexual offender registration. Ladies and gentlemen, just to be quite frank with the 6 of you who are here today, quite often in my experience in these cases, when a man is faced at the possibility of going to prison for the rest of his life and becoming a registered sex offender and given an option to go on deferred adjudication for 5 years without registration, oftentimes, obviously, that calculus forces a person to take probation for something that they will continue to insist they haven't done. Mr. Crawford was placed on deferred adjudication in August of 2023. He was supposed to be on deferred adjudication through August of 2028. That deferred adjudication was terminated early. It was terminated successfully.
An objection that was not in the SO hearing.
We got to limit to Mr. Martinez to what's at the SO hearing. We can't admit new evidence to
I will proffer to the court then, to the commission, that Mr. Crawford was never found guilty of anything. And that he did take advantage of this opportunity that he was given on probation to get his affairs in order. He did get out of a bad relationship. He has not gotten himself back into those things. At no time were any accusations made that Mr. Crawford was a danger to his clients. No accusations were, or evidence was introduced that Mr. Crawford had somehow been a danger to the community in his capacity as a barber. In fact, there's no indications at all that his behavior as a barber was anything other than in compliance with what we would expect as a barber. There are no other holds or obstacles to him having a license. He has completed probation successfully.
And objection, again, this was not in the
And-
SOA hearing.
And what I would argue in the hearing was that it was presented at that time that he was given conditions of probation and had been in compliance with those. So I do very much disagree with the assertion that there was no evidence of rehabilitation, no evidence of supervision, because certainly he was doing those things at the time of the hearing. So the accusations are essentially that he's unfit to be a barber when there's no indication at all that he's ever done anything other than be a satisfactory provider of barber services to the public. And secondly, it's that he was misleading and untruthful in his disclosures, which, as I've told the commission, he filled this out himself, and I think was unaware of his obligations to disclose anything that did not result in a conviction. Mr. Crawford is not asking for anything other than the ability to continue working. And I don't think that the prosecutor's been able to show any reason why he should not be able to do that. And both myself and Mr. Crawford are available for questions.
Thank you, Mr. Martinez. Questions, Commissioner?
Councilor Rivers, Netley, real quick. We are here to talk about what the SOHA or the ALJ's documents, right? Not the new evidence and so on and so forth. I hear you've been objecting.
Yes.
Okay. I understand. Thank you.
Okay. Any other questions, Mr. Commissioner?
Ms. Olivera, on page 15 of the PFD, it refers to the fact that he answered no to the question about specifically deferred adjudication. Was the question specific to a deferred adjudication?
Yes, I can read the question. It was
Okay.
admitted into evidence. The question on applications also for new, and was renewal application. The question asks, since your most recent license was issued, have you been convicted of or have you been placed on deferred adjudication for any felony or misdemeanor other than a minor traffic violation? And respondent's answer was no.
Okay, thank you.
Any other questions? All right, I'll take a motion, Commissioners.
Chairman, before there's a motion, there would be two clarifications to this PFD. In terms of conclusion of law number 11 and conclusion of law number 12, they would need to be clarified. There's confusion with the term petitioner. So we would request that you instead insert his name at the beginning of both Avery S. Crawford for number 11 and Avery S. Crawford's Class A barber license for number 12.
I'm reading that in the, is that accurate or are we modifying that? I don't understand.
It would be modified, correct?
Okay, okay. All right, all right. Commissioners, any comments or a motion?
Chair, I move to accept the PFD with the clarification as mentioned by council. I think it says department is a petitioner. That should reflect Avery S. Crawford as a petitioner. And the conclusion number 11 should be rewritten. Avery S. Crawford is not currently fit to hold a Class A barber license, Texas Occupational Code Section 51356, 5302, A1, .022, 023, 025, Department's guidelines for license application with criminal convictions. In conclusion of law number 12, the commission should revoke Avery S. Crawford's Class A barber license at this time and deny the pending renewal Class A barber license request.
Is that correct? You read it right. Okay. And is there a second to that motion? All right. All those in favor say aye.
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 Opposed? All right, motion carries. Mr. Martinez, Mr. Lewis, You can get with staff if you want your next steps or options are available to you. Thank you for
Thank
your
you, sir.
time. Item number 4, London Services and Christian Guthrie. Guthrie?
Good morning, Commissioners. For the record, my name is Kristen Guthrie. I represent the department's Lottery and Charitable Bingo Division at contested cases at the State Office of Administrative Hearings. I am here to recommend that you adopt the proposal for decision issued in London Service LP in its entirety. It was issued on February 11th, 2026. The proposal for decision concluded that London Service LP failed to meet its burden to show that it timely filed a renewal application, and it found that the division properly denied the renewal application. The SOA cover letter issued with the PFD notified both parties of their opportunity to file exceptions to the proposal for decision. Exceptions are the formal mechanism for a party to challenge any part of the PFD, including the ALJ's recommended outcome, and to raise objections or complaints about the ALJ's findings or conclusions. London Service LP chose not to file exceptions and cannot now argue for a different outcome at this meeting. Accordingly, the division respectfully requests that the Commission adopt the proposal for decision and enter a final order denying London Service LP's renewal application. Thank you, and I'm available to answer any questions you may have.
Any questions? Mr.
Council.
Armstrong?
So if someone doesn't file timely, is there an extension time or something allowed by statute?
No, only upon request, the ALJ could extend, but no one requested extension to file exceptions.
Thank you.
Any other questions?
So there's not a 60-day automatic extension?
I mean, for the renewal application, there's a 60-day extension if they, in this case, the renewal application expired on October 31st, and there's a 60-day extension if they file by December 31st, but that did not happen here.
Okay. Any other questions? Okay.
Good morning, Chairman, and good morning, Commissioners. My name is Drew McEwen, and I represent London Service in this hearing. So this case involves the renewal of a commercial bingo lessor license. It was a grandfathered lessor license, and London Service held that grandfathered lessor license for several decades. The license was set to expire on October 31st, 2023. And the bingo hall's bookkeeper for over 15 years, Miss Christine Bannister, testified at the oral hearing. And here's a quick recap of both her testimony and the documentary evidence. Ms. Bannister received the renewal application from the bingo division on September 20th or 21st of 2023. It was right before she went on a short trip with her mom over the weekend. Ms. Bannister mailed the renewal application at the USPS branch on Balcones. She also mailed another license renewal application that was on administrative hold, along with 2 checks for that for the license fees. And Ms. Bannister also filed quarterly reports for London by mail on October 25th, 2023. And critically, this mailing also occurred prior to the expiration of the license. Now, the bingo division didn't receive the renewal application in check. It did receive the quarterly reports that were also mailed, again, within the application deadline. The ALJ ruled in favor of the bingo division and held in the PFD that London didn't meet its burden of proof that the renewal applications were mailed prior to the license expiration. London respectfully requests that the Commission decline to adopt the PFD as written and instead reinstate London's grandfather commercial lessor license. I believe this request is supported by 5 key points. First, the testimony of Ms. Bannister was clear and unambiguous that she mailed the application and check on September 26, 2023. Ms. Bannister doesn't have a direct financial stake in this matter. She's the bookkeeper at the bingo hall, regardless of who the lessor is. Second, the documentary evidence included bank records before and after September of 2023. And those bank statements showed that all sequential check numbers were written before September 26, 2023 cleared. 2 checks from the renewal application didn't clear, and the check number sequentially after those 2 checks started clearing in October of 2023. Third, the record reflects that the quarterly reports mailed on October 25th, 2023 were received. This corroborates Ms. Bannister's testimony and supports the accuracy of her mailing process and memory. Also, just as a thought experiment, why would she write 2 checks for renewal application, yet failed to file the renewal application, and yet again go ahead and mail London's quarterly report less than a month later, which was also before the deadline for the renewal application? Fourth, your predecessor, the Lottery Commission, issued a decision in Town West Bingo that supports London's position that it met its burden of proof through both testimony and corroborating documentary evidence. Now, in the PFD, the ALJ did say that, but unlike Town West Bingo, there is no corroborating evidence from a postal employee or any other individual. That's an accurate statement. However, in Town West, there needed to be corroborating evidence, or corroborating testimony rather, because the primary testimony was from the license holder himself. He was very much an interested witness. That's not the case with Ms. Bannister, who is a disinterested party. Fifth, the Bingo Division has an arbitrary and unjust policy of immediately notifying a licensee if it fails to file a quarterly report, yet waiting until after the expiration of the 60-day grace period to notify the licensee that its renewal application wasn't received. Simply put, London met its burden of proof that the renewal application was timely filed by mail. The burden here is preponderance of the evidence. That is it more likely than not that London mailed the renewal application on time? We believe that it is more likely than not. London met that burden, and it respectfully requests the Commission reinstate its grandfathered bingo commercial lessor license. Thank you.
Questions, Commissioners?
Yes, sir. I have a question. Ms. Bannister was the bookkeeper, correct?
Yes, sir.
I'm guessing she closes out her books at the end of every month. Did 2 months expire with outstanding checks? Did that never register?
She did. No, she was not as diligent as she should have been in reconciling the bank statements. That is correct.
So she closed out 2 months with balances?
Correct. Well, no, she didn't reconcile the bank statements with her financial records for those 2 months. That is correct.
Putting the bank statements aside, when you close out the month, you would have outstanding balances, right? Things would be out of balance. You would have 2 outstanding checks in September, or if you rolled it over till October, assuming that the checks were in the mail. October, November, they would not have balance. You would have had out of balance at the end of the month for 2 checks, correct?
That is correct.
And that should have triggered something, at least in my very feeble mind.
Yes, sir. You are correct. It would have triggered something had she done a reconciliation of the bank statements with the financial records.
Okay.
Any other questions? Yes, sir.
Council, real quick question. Simple.
Yeah.
Okay. Was supposed to be mailed by, I think the license expires on October someday, 31st. Don't you think that it is important, you guys been in 15 years in business or whatever it is, that, hey, something flag right there, we don't have some check or something going on. Can't they pick up a phone or something? Or is there any check? Why didn't we get a renewal rather than going through all this trouble?
So that's a great question. In the past, what she had done is she had hand delivered those renewal applications to the commission whenever it had. So it relocated from 6th Street to this current building, or close to this current building. And after that time, there weren't instructions on the renewal application for hand delivery to that location. Now, there's subsequently, the Bingo Division's witness did testify that they would have accepted hand delivery, but the information and instructions on the actual renewal application said that it needed to be mailed by, or it needed to be filed by mail. So that's what she did. And in the past, she hadn't had any issue again with the actual renewal application being accepted or received, accepted, and then approved. And there's not anything that the bingo division, at least to my knowledge, issues proactively saying, hey, we received the renewal application, it's granted, you're approved for another 2 years.
You know, there's a grace period of 60 days right there. Okay. Your staff didn't provide, your staff didn't provide that, and the burden of proof gets on us to prove it right there. So this is a process been taking for a long time. And I'm surprised that the arguments right there, whatever it is, we got to follow the ALJ. And that's where the evidence all meets. The rubber meets the road. Here we got to look at the simple facts. Did they follow the law or not? That's where we end up. Thank you.
A couple of quick questions, Mr. Chair.
Go ahead, Vice Chair Buller.
Because this is a new program to us, I'm going to ask a couple of questions to kind of understand the process. Are all bingo applications paper applications that have to be mailed?
I'm not the best person to ask about the bingo process itself. We might have someone from bingo division here that could answer that. I believe
Is there somebody from bingo that could,
Samantha Phillips was our witness in the case, and she's here.
Ms. Phillips, would you please? So are all bingo applications paper applications? Do they have to be downloaded and filled out? Or is there an electronic version that can be done electronically going back to 2023?
Yeah, most applications are paper, but there are also electronic applications via a bingo service portal.
So could that have been, could London Services have availed themselves of an electronic?
No, the renewals are not a part of the set of applications that are available online that way.
Okay.
Okay. Any other questions?
Just one
Right.
further one about about Ms. Bannister. Did she not have a practice of making copies of checks and applications that she dealt with?
She does typically have a process of making copies. In this case, she made a copy of one of the application renewals, but not the London application renewal. So there were two that were mailed at the same time. One was for Roman Services. It was a license that was on administrative hold. She made a copy of that. And then she believes that she made a copy also of London Service, but couldn't locate the copy of that for the oral hearing. And so she had a copy of the Roman Service application renewal, but not of London Service application renewal.
And sir, when you say they were mailed at the same time, are we talking about two separate envelopes?
Same envelope.
And neither of them were received, correct?
Correct. Yes, the actual envelope was not received.
All right. Any further questions? Take a motion.
Chair, I move to adopt the PFD with the correction to the, which is, I think, the conclusion of law number 7 to reflect the rule citation in effect at the time of the violation. 16 Texas Administrative Code, Section 402.411B.
Okay. Is there a second? All right. All those in favor say aye.
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 Those opposed? Motion carries. Thank you. Appreciate your time, sir.
Thank you.
Okay. Commissioners, we're going to do motions for rehearing. Deanne, do we have anybody representing the other side on either one of these?
No, sir.
Okay. Okay. Mr. Thunderberg, yes.
Good morning, Chairman, Commissioners. I'm Christopher Funderburg, Assistant General Counsel. Based on an investigation, and this is regards to Manu Royal Touch, based on an investigation performed by TDLR's Enforcement Division, TDLR alleged respondent committed 2 violations of the laws and rules governing barbering establishments. The case was resolved by default, and respondent filed a motion for rehearing. The initial notice of alleged violation was sent by certified mail to respondent's business address of record to department on October 15th, 2025. The USPS website Track and Confirm records the status of the certified mail on October 23rd, 2025. Excuse me. As delivered, left with individual.
Ma'am, Are you representing? You are?
I'm the owner, yeah.
Okay, okay, all right. Be great. Just make sure, you're gonna have to speak up, but also I'm gonna need you to fill out a public comment form, so make sure you do that, okay?
Okay.
You are,
Magnela Jubisi.
I'm sorry?
Magnela Jubisi, the owner of Manu Royal Touch.
Okay, okay.
Chair,
Okay,
point of order.
just hang on a second. I just need you to, okay, just give me a second on this, okay? Mr. Vandenberg, we'll start over with you in a
I'm
minute.
sorry, did I go out of order?
No, just you can just stand by. I'm just gonna have you start over. Yes, sir.
Thank you.
Council, Chair, this is a rehearing, which the department, so I want to get the advice of the general counsel.
About what?
Is it debatable right here, or how does it happen?
No, she's gonna represent, she just needs to hear the
Motion
instructions.
For rehearing, and she's allowed to express, she filed the motion.
To appear here?
Yes.
Okay, thank you.
She did, but she did not
Just a
respond
second,
when we
hang on a second.
requested.
She'll,
assurance.
this is standing by. She'll fill it out a form. Now, I'm gonna read you some instructions in a minute that I didn't read because I didn't know you were here, okay? So I'm gonna give you a minute here, okay? So let me read these instructions to you before he starts again, all right? And make sure you let me know you understand. We'll hear from the general counsel first, then we'll hear from you. You'll have an opportunity to speak. Make sure you speak clearly, state your name, and you'll have 5 minutes to make communication. Is that clear?
Yes.
Okay, okay. All right. Is that good? Good, okay. Vandenberg, go ahead.
Thank you. Respondent's motion for rehearing was filed timely and its contents meets the substantive filing requirements. But as the evidence in the enforcement case file and respondent's motion for rehearing shows respondent's failure to answer the NOAE was not due to accident or mistake, the General Counsel's office recommends that respondent's motion for rehearing should be denied.
Okay. Any questions, commissioners? Okay, and your name one more time, because I'm sorry, you have to hit your button, make sure the button's on.
Magnela Jubisi. Magnela Jubisi.
Okay, go ahead.
So what's the question again, please?
Well,
You're gonna, ma'am, you're gonna have to tell us where we erred in the processing of your case, okay?
Okay.
So we're not trying to relitigate this case, we're just gonna see if there's an error in this case. Does that make sense?
Yes.
Okay, go ahead.
Anyway, I'm here because I received the mail in the mail about the fact that I had some stylists in the shop that was no license. Yeah. So I've been doing this business for like 8 years. I started like Manu hair braiding. We were just doing braid. So people know us as a braiding shop. Of course, I have braider. In the state of Texas, you don't need the license to be a braider. And I also have the fact that I have a barber in the shop that was not licensed. And that was not true because I never had a barber that was not licensed. That barber is here on the file was my husband. And
I apologize for interrupting. Yeah, we were not here to litigate the
Right.
underlying facts of the case, just whether the notice file, whether she was properly served with notice.
Right. You understand what he's saying?
no.
Okay. We're not here to go back through the details of the case.
Oh, okay.
Okay, we're just here to understand if we made an error in notifying you or processing this case. That's what a motion for rehearing is.
Oh, okay. No, I don't think you guys made an error. No.
Okay, okay. Then that's all we're contained here. That's all. You had the opportunity within the SOA hearing to go through. I'm going to have a staff go through with you
Oh, okay.
in the process to make sure you understand what happens, okay?
Okay, thank
All right.
you. It's my first time, so I'm very lost.
No worries. This is fine. We'll make sure and follow up with you, okay?
Okay,
But
thank
right
you.
now, I need to address the issue for the motion right now, okay?
Okay.
So stand there. Any questions, commissioners? Okay, I'll take a motion.
Chair, I move to deny.
Okay. Second? All in favor, say aye.
Aye.
Opposed? All right, motion carries. Staff's going to get with you and let you know, if you don't mind, Courtney, have somebody follow up with her and just make sure you understand what we were doing, okay?
Okay, thank you.
Thank you. All right. No more surprises anymore. Is there somebody representing Bethina? Here.
Denicia Bethia. There was no response to us to our request, but she may be in the audience.
That's nobody going once, twice. Okay, Mr. Funberg.
Good morning, Chairman, Commissioners. I'm Christopher Funderburg, Assistant General Counsel. Respondent filed a motion for a rehearing arising from a contested case in which the department proposed to deny respondent's application due to her criminal history, specifically petitioner's conviction for conspiracy to sex traffic persons. Respondent's motion for rehearing is timely and it raises one major ground of alleged error, specifically that the commission erred in its conclusion that respondent is currently unfit to hold a cosmetology license. Instead, respondent argues that since her release from federal prison in October 2023, she's made consistent and meaningful efforts to rebuild her life and demonstrate positive change, and thus is fit for licensure. But to the extent that the evidence underlying respondent's argument in her motion for rehearing was considered by the ALJ during the hearing, it was found insufficient to overcome the department's allegation that the respondent's criminal conduct renders her currently unfit for licensure. Also, to the extent that the evidence presented in respondent's motion for rehearing is new evidence of her fitness for licensure, it cannot be considered as it was not part of the administrative record. Therefore, respondent's motion does not allege any error for which relief can be granted, and is therefore without merit, and the General Counsel's Office recommends denying the motion.
Any questions, Commissioners? I'll take a motion.
Chair, so move to deny.
Second. All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you, Mr. Funderburg.
Thank you.
Commissioner, we go item I, Stephen Leary. Good to see you, Mr. Leary.
Good to see you. Good morning, Commissioners. Stephen Leary, Assistant General Counsel. Item I consists of the new program rules for a new program that's come to TDLR, the Residential Solar Retailers and Salespersons Program. This program came to TDLR as a result of Senate Bill 1036, the Residential Solar Retailer Regulatory Act. We would have named it something better, but we couldn't come up with anything better. Under the Act, TDLR will regulate certain residential solar transactions. The salespersons, along with the companies that employ the salespersons, who are known as solar retailers, will both have to register with the department as of September 1st, 2026. The proposed rules provide details regarding the registration and insurance requirements, specify certain requirements relating to the form and format of the solar contracts, and create a code of conduct for retailers and salespersons. Under the proposed rules, the department will promulgate a consumer educational brochure and a mandatory disclosure form, which the salespersons will be required to furnish to the consumers. The proposed rules contain provisions relating to a 5-day right to cancel, which is provided by statute, along with provisions relating to fees, refunds, and enforcement. These rules were developed with the assistance of a stakeholder work group that consisted of representatives from the solar industry, consumer groups, including the AARP, and partner government agencies, which included the OAG's Consumer Protection Division, the Public Utility Commission, the Office of Public Utility Counsel, the Office of Consumer Credit Commissioner. The proposed rules were published in the March 13th issue of the Texas Register. The 30-day comment period closed on April 13th. In all, we received 29 comments, which included comments from a variety of industry, consumers, and interest groups. In response to the comments that we received, which we also reviewed those comments with our stakeholder work group, I'm recommending a few changes to the proposed rules, which are shown in red text in the written materials. These changes, one of the comments we received a lot was that the language that a contract is written in should match the language that a sales presentation is presented in. So when the door-to-door salesman come to someone's door and give a sales presentation, that the contract should, if they give the speech in Spanish, the contract should also be written in Spanish. So I recommend making that tweak with the exception that if the consumer requests it to be in a different language, it'll be in the language the consumer requests. I also removed a reference to subchapter B, which was erroneous because subchapter B is reserved for expansion. We're going to separately develop continuing education requirements for this program. And some clarifying language has been inserted regarding the dates that the enforcement provisions begin to apply, which is September 1st, 2026. I recommend the commission adopt the proposed rules with the recommended changes. I'm available to answer any questions.
All right. Thank you, Mr. Leary. Any questions?
Chair, I got a couple of questions.
Yes, sir.
Council, what bothers me is requiring contracts to be provided to consumers in the language of sales presentation unless the consumer requests otherwise. Can you explain me that?
Sure. So there are a number of people who have limited proficiency in more than one language. So people might be fluent conversationally in Spanish, but they might only understand, well, really, usually it's the other way. You might be fluent conversationally in one language, but understand legal documents in another language. So I felt that if we made it the rule across the board that the language that the contract's written in had to match the sales presentation, it could have an unintended consequence. That someone, for example, could knock your door and give you, and you speak Spanish, you speak English, you speak whatever language you speak, and they could talk to you about solar panels, give you the spiel in one language, and then the contract would have to be written in that language, and that may not be the language that you are the most fluent in understanding legal documents. So I attempted to strike a balance there in that there's a presumption that whatever language you approached the customer in and gave your sales presentation in, that if that's a language other than English, that the contract has to be provided in that language. And that's to protect consumers. But if the customer says, "Hey, I don't want the contract in that language. I want it in a different language," and maybe that's the language that that person's friend or son or somebody who they trust speaks. We wanted to give the consumer the ability to request it in a particular language. We want to honor the consumer's choice. So that was the rationale behind that change.
So that gives me a pause to ask you several questions. What's the law written? In which language is the law written? English, right?
Yeah. Well,
So what are the unintended consequences of asking a language right there? Because I speak other than English, couple of them. Okay.
okay.
If I request them to give in a language other than the English right there, are we burdening the courts because the language would be completely English compared to I may speak couple of them? So are we not burdening the court system by allowing languages? If they want to interpret whatever it is, but the language sales contract has to be one because it has to be enforced in a law of court or whatever it is, it may come back to us. Then we got to go figure out how many languages we got to learn, or we need to stick it in the AI to tell what it is. I think the unintended consequences of having different languages is going to be burdensome for the agency. That's my perspective.
Well, and just to clarify this a little bit, the rule in question is Rule 71.40, which presumptively the contract has to be written in English. If you make the sales presentation in a language that's partially or totally in a language other than English, then the contract has to be written in the other language unless the consumer requests another language. So to use your example, if I were to ring your door and try to sell you solar panels, if I did that in English, you wouldn't have the option to require a contract in Farsi or any other language. The contract is going to be in English. It's only if I'm targeting consumers and going to your door and giving you a sales presentation in another language other than English, then the contract has to be is going to have to be in that language unless you requested another language. So this is designed to protect our elderly consumers and consumers with limited English proficiency, that if the salesperson is targeting consumers and pitching to consumers in a language other than English, that's the only time that the consumer has to get a contract in a language other than English, if that makes sense. It's not designed that the contract has to be provided in any language other than English if the sales presentation wasn't in a foreign language.
So this again gets to the point right there. If you're like, for example, you said Farsi. Let's take example right there.
Okay.
You got to put the burden on the sales guy for going and selling something in the language other than what is commonly understood here. So I think, I'm not comfortable with something other than a simple language right there, because I don't want to burden our staff with employing different languages for understanding what it is. It ought to be the sales guy's choice he can get an interpreter and you can request the interpreter to sign an affidavit that this is what was sold. And so at least, you know who it is, rather than trying to come back and say, oh, then they'll come back and say, oh, I don't understand this language, or I get, so the unintended consequences are pretty severe on this language barrier. That's my take.
Commissioners, you can also, another possibility is you can also make a motion to have this rule, to pass it as written, because these are additions based on the comments. So you could do it as written and it just, as published, excuse me, as published, and that would be written in English. The other thing to consider is possibly if you wanted to tweak it to say that the contract is in English, but that a copy of it must be provided or could be provided in the language of the sales pitch.
Oh, yeah, it's just to clarify that in the proposed version that went in the register.
Mr. Leary, hang on, just
Oh,
give me a
sorry.
second. Hang on a second. I think Commissioner Butler wanted to add one.
Sure.
Okay.
Yes, sir. I understand Commissioner Droxaram's desire to have one language, right? We all have to have one sheet of music that we can play, right? And I think, whether it's a contract that's going to be argued in court later, everybody's going to have to read a contract in Farsi, right? And that puts the judge and everybody else at a disadvantage. It's an odd concept to have to do, right? To argue a farce. I don't want to say farcical, whatever Farsi is in its idiomatic sense. So, I kind of, you and I were thinking the same thing. Because this is a regulated industry, could we have an English contract, which is the baseline contract? And because I do want to give the consumer the power to understand what they're entering into, whether they can read English or not, right? Can we mandate an English contract so that if down the road there is some argument as to what was supposed to take place and what did take place, we all understand that, right? Anybody that walks into the situation, whether it's the OAG, and I'm interested to hear what the OAG had to say about this as well, because you said they have weighed in on these rules. So I'm interested to hear what they had to say, but I like the both. I like, if you're going to pitch something in a native language to somebody, you could do anything if you change that to English. So I think the burden should be on the salesperson and that company to say, this is the English contract if we have to go to court and there's some disagreement. But you also have the right to understand it in the language that I sold it to you in. That's only fair, and I think that gives the consumer the power that they need and some satisfaction that they're entering into the agreement that they've agreed to. So I think if we're going to do this, if we're going to go down this road and it opens a can of worms in different ways, then we should at least have some baseline that we can all understand.
Mr. Chairman.
Hang on. Commissioner Castaneda.
I was wondering, aren't we at the point where the federal government has said everything is in English? English is our first language if you're in the States.
I'm not sure if I can answer that one or not.
I don't believe Texas has an official language.
I was just curious because if we give it to them in English, wouldn't it be up to them, maybe before signing the contract, if they could get it read by somebody translated, rather than I'm for the consumer, but I do believe it's, as Chairman was saying, Butler was saying, I believe it'll be difficult if it does go to court. And then now we need an interpreter at the court to try to explain the various contracts.
Okay.
If I could clarify just a couple of things in response to some of the questions I'm getting, I just want to make sure there's an understanding. So in the version of the rules that was proposed in the register, we did not have in here that it has to be in a language other than English. That's a change that we're proposing to make in response to some of the comments that we received. And we received comments like that from a number of groups, including the Texas Elder Justice Coalition, the SMU Law School Consumer Clinic, and the Solar Industry Association, Texas Solar and Storage Association, This is sort of an industry standard in the solar industry to provide a contract in a language that the sales presentation is in. So this is an additional something we added in response to the comment. We could certainly take that out. But the other thing I wanted to clarify is that part of the regulatory scheme is that there's going to be a disclosure form that TDLR actually drafts, and we're going to put on our website. And that'll be in English and in Spanish. And the salesperson is going to have to fill in boxes for key terms of the contract, such as whether this is a lease, a purchase, or a power purchase agreement, the interest rate, the total sales price. And that form is also going to contain language about the right to cancel and how to cancel the transaction within 5 days. So providing that disclosure form in English and in Spanish, that might ameliorate some of these concerns. So I just want to give you the full picture there.
Mr. Chairman?
Yes.
Derek Burkhalter, Assistant General Counsel. If I could maybe propose a solution here, that the contract must be written in English unless another language was presented, but a copy of the contract must be provided in that other language. And then we could go with the language that Mr. Leary's presented to change, but just add in there a copy of the contract must be provided written in the language.
Right.
And then with that change, I think we could.
I think that's fair. And it brings in the consumer protection that we need for people who are not able to. So I agree. All right. Do you, any other comments?
Yes, sir. The OAG, could we go back to that? What part did they play? And
they were a part of our stakeholder work group. So because this program doesn't have an advisory board, the Act created a stakeholder work group that we worked with in developing these rules. And we've been working with them for about a year. OAG has, they're a part of that work group. They provided feedback during this process. Along with all those other agencies and groups, we have a representative from the Solar and Storage Association, Office of Consumer Credit Commissioner, OAG, and so forth. OAG did not file a formal comment through the register, but they've been providing feedback as we go along and as we drafted the rules.
Okay, thank you. Anything else?
Of questions.
Sure.
Does the Senate Bill 1036 require us to have languages or anything more specific, or it is a general statute?
It's fairly general. There are some things that are required by the statute as far as what has to be in the contract, certain disclosures we have to include. But as far as the language of the contract, it's silent on that issue. It gives us the power by rule to regulate the form and format of the contract.
So we inserted ourselves into this language stuff right there.
Right. We stepped into that when we got the public comment, and then we decided to try to make that change.
So we decided to get into this because some people wanted us to add or subtract or something, and according to council right there, the contract has to be in English, and if someone requires, you can have it in whatever language it is. So you lawyers are pretty smart right there. If both of them are different, because you know what, it's come back to haunt us, because you know what, the guy sold me in language A, this one, in language B is what it is written right there. Why do we add to more complexities of what it is? And this is a rule, I think, if it is per statute, let the dome people decide that it has to be in whatever language it is, we'll follow. If not, I think, we are venturing into something, we're going to end up asking. That's what, I'm not comfortable with the language aspect.
Mr. Chair, if I may. Thank you. Thank you so much, Mr. Chairman. If we do enter into this, would it not be fair for an electrician customer to say, why isn't my contract in Farsi? Wouldn't it be fair for an air conditioning person to say, why isn't it in Farsi? Would it be fair for a lottery scratch-off ticket to be written in Vietnamese? Why would it not be, because those are contracts, why would it not be incumbent on us to ensure that every contractor in the state of Texas issue a contract in whatever language anybody deems appropriate? Why should we just limit it to this program, the solar installers?
That's a great question. My answer to that goes to the public policy behind this bill and the history behind this bill, which Senator Judith Saffarini had proposed. And it was directed at a specific problem, particularly predatory sales practices that were occurring with door-to-door salesmen. And there were many complaints. The department has received many complaints about this, but because we don't regulate the solar sales, and we before this bill came along, we only regulated the installation side. We weren't able to do anything with those complaints. And OAG Consumer Protection Division was also getting a lot of complaints. There have been many horror stories of elderly people being taken advantage of, being required to sign or they get tricked into signing a contract on the iPad, and then they get a $60,000 lien on their house. And there's a lot of public outcry that came about at a time in history when there was a tax credit for selling solar panel, for buying solar panels. And so there was a time when a lot of bad actors came from out of state, and they were going door to door, and they were particularly targeting vulnerable populations, particularly the elderly and people with limited English proficiency. So I think the public policy behind this act and behind this rule package, it is unique and it's somewhat different from our other regulatory programs. Certainly you could have an air conditioning contract that takes advantage of people. People can be tricked into buying the mega compressor they don't need. Sometimes they sign a loan with that compressor. Solar is a different deal. Solar, this is a major financial transaction. We're talking about sometimes people have a 30-year loan that goes along with these solar panels, and they're selling it to an 80-year-old woman. It's a major financial transaction that makes it harder. It can make it hard for you to sell your house. It has wide-ranging implications. So I understand the politics behind language and behind English being a preferred language and all of that. And that's really beyond me. But in some of our programs, we do require this information to be produced in a language other than English. It's not entirely without precedent. I think we do require that in a number of programs, but it's important to keep in mind the unique public policy and history behind this particular act. And so I think that's why all those groups were concerned about particularly sales pitches coming in Spanish and then handing them a contract in English that they don't understand.
I'm thinking of possible solutions. And so could we put the burden on the company to say, you have to provide us some proof that they understood that in the language you presented it? Not a mandate, but just say, you have to provide us some proof in the end that they understood, right? That's the essence of a contract. You have to assent to the same thing, right?
Yes, sir. And we're trying to get to that aim a number of different ways with these rules. So, the issue about the language in the contract is one issue, but there's also that we prohibit certain kinds of sales practices. There's a cooling off period that's built into these rules so that you have to give them a brochure, then wait a certain number of days before you consummate the transaction, which is designed to give the consumer a chance, if they don't understand what they're being presented with, to go get help and understand it. And you have that 5-day right to cancel so that someone can back out if they realize they've signed a contract. So they're all aimed at this. They're all aimed at transparency and in making sure the consumer can make an informed choice. And one proposal that got suggested by the industry was to require a welcome call be recorded. So it's to require that, once the consumer has signed the contract, that they do a video call where they go over the contract terms, they make sure that they understand them, they give them a chance to answer questions, and they keep a copy of that video, and they use that as evidence down the line when someone wants to challenge the contract or say that it wasn't voluntary. So they do that to cover themselves. SEIA had and I think Texas Solar and Storage Association also kind of advocated for that. And I wasn't sure that we were ready to go in that direction yet. There are some practicalities behind requiring this recorded sales call, how long they would have to retain that for. So We didn't go in that direction ultimately, but I guess I'll say that all of these measures, all these protective measures are really designed in that same vein. It's just to prevent exploitation, to make sure that consumers make an informed choice, that they understand what they're signing. And that also protects the industry against later claims that that someone didn't understand what they were signing.
Absolutely.
Chair, one last
on.
question.
Okay, so I just want to make sure that, is there any other comments that we need besides, I know you guys are gonna be going back, other commissioners?
Saying the change.
Hit your button.
The change that Assistant General Counsel, Derek had put in could be worded in to let us go ahead and
Right.
get these in place.
And I just want to remind Commission, this isn't we can revisit this. Obviously, there's a response from the OJ, which is a predatory problem that we have here. So this isn't a static document. It can breathe and we can modify down the road. So this isn't a fix all solution. So, but let's wrap this up. What else you got?
So council, like Texas Real Estate Commission, okay, has an English language and everything, the format is pretty much straightened right there. Why can't something be done in that way? Because then it becomes a lot simpler, the contract right there, because people buy homes the way it is written and there are no surprises. It's one standard document out right there and it takes care of it. And the recording again happens in English right there, okay? So I'm not comfortable with this language stuff, but at least we can start developing a standard format for the industry that once a sales guy goes in, that's what it is. I think that's a form we need to regulate. But when we have different languages, what happens if one is different from the other? You know, we'll end up litigating it. ALJ, SOHA will club it, and it's a circus right there. That's what my concern.
All right, let's get this last comment.
If I may, Mr. Chair, I think it's a balance, right? How do you protect the consumer and not force commerce into 30 different languages in a contract? It's an odd thing we're struggling with, and we're all trying to get our arms around it and understand it because the implications are so big. I can tell you, in my industry, if we get a home equity loan wrong, the penalty is they don't have to pay. So we have to make sure we get it right. So I think maybe taking a page out of financial institutions, if industry gets it wrong, maybe the penalty is so severe, they don't have to pay. Okay? If the penalty is severe enough, you're going to get it right. I promise you. Because I can't make a loan for $100,000 and they go, hold on a second, you didn't notify me 3 days in advance, or you didn't give me 3 days to get out of it. I have to do those things, or they can walk away from the loan. So I think that's probably a better way to address this, is make the penalty so severe that industry, I mean, if you cheat a little old lady out of $60,000 and file a lien against her property, and if the remedy is she doesn't have to pay, and you better take that lien off, or she gets to sue you. I think that's how you address these things. Make the penalty severe enough that actors have an incentive to do it right, not necessarily forcing them to do it in other ways, right? So that's just my 2 cents.
Any other
Mr. Chairman.
motions?
I'm sorry, Mr. Chairman. I just need to add a detail that a colleague brought to my attention through a chat. In the Business and Commerce Code, Texas, section 601.052, there is already a requirement in the statute that says, subsection A merchant must provide a consumer with a complete receipt or copy of a contract pertaining to the consumer transaction at the time of its execution. Subsection B, the document provided under subsection A must be in the same language as that principally used in the oral sales presentation, contain the date of the transaction, contain the name and address of the merchant, and contain a statement basically saying that the buyer can cancel the contract within the 3rd business day. And so that is in the Business and Commerce Code.
If I can, I mean, I hate
Hang
to.
on, Mr. Larry, just give me a second here.
Okay.
I know you love this thing, but I just got to give me a second.
All right.
Any other comments from the commissioners? Okay. Just wrap it up, Mr. Larry.
Oh, yeah.
30 seconds.
So the point about 601 Business and Commerce Code, that's a right to cancel. It's a cooling off for door-to-door sales. This statute was based on that in part. It expands your rights under 601. But that provision isn't requiring the whole contract to be in another language. It's requiring the notice of the right to cancel to be in the other language. So it's a little bit different. So I just want to make that.
But the code is relevant. I got you. Okay. Is there a motion?
I'll make it.
Is there a second?
Chair, you want to extend the decision? What's the outcome, council? Can I ask the council?
Yeah, go ahead. Go ahead.
I'm sorry, what is your question?
The question is, I have a problem with the language stuff. Okay. Again, Council Leary said that right to cancel, that's what it is. So you're telling me that the current statute does allow to have it in a different language? Is that what I hear?
Yes, the current statute requires the contract to be provided in the language that was principally used in the oral sales presentation.
It says stating what he's stating already.
Yeah.
Okay. I got a motion. Is there a second? Motion dies of a second. All right. Any other motions?
Mr. Chair, I think Mr. Burkhalter, I'm understanding from council here that it pertains only to the right to cancel. Is that, and we're just kind of
Yeah, we're
going in
spinning-
circles
Yeah,
here.
we're going in circles. That's what I'm saying. We either accept that language or we can lose it, but I need a motion. That's what I need.
So if I could just clarify, so yes, Mr. Leary is correct that it refers to the right to cancel, but that section does require that a copy of the contract be provided. And so if we amend our language as I recommended, where they only have to provide a copy in another language, then I think it fixes all the problems and it maintains consistency with the Business and Commerce Code.
I'm going to make a motion that we accept the rules without the language provision.
Okay. Is there a second?
Second.
Okay. All those in favor say aye.
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 Opposed? Nay. Motion carries. All right. Let's go on to Jay. Larry.
Good morning again, Commissioners. Stephen Leary, Assistant General Counsel. Item J consists of a new rule and amendments to existing rules in the electricians program regarding an accelerated journeyman electrician education or Jeep program. The rule package was developed at the request of Texas State Technical College, who plans to begin offering an associate's degree program in electrical construction in the spring 2027 semester. The rule package seeks to address the current shortage of journeyman electricians in the state. Under the proposed rules, that the new pathway is established under the Commission's alternative qualification power under Texas Occupations Code Section 51.4041A, which gives the department the authority to establish alternative means of qualifying for a license and to take into account an applicant's education, training, and experience. By way of background, under the current law, under Occupations Code 1305.155, to be qualified for a journeyman electrician license, the applicant has to complete 8,000 hours of on-the-job training and pass our examination, which consists of 2 examinations. The code, examination on the code and an examination on code calculations. On-the-job training is currently defined in our rules in Rule 7310 and includes electrical work that's done under the supervision of a qualified electrician. Under the department's current policy, an applicant can sit for that exam after completing 7,000 hours of the required 8,000 hours to become a journeyman electrician. That policy is not currently reflected in the rules. It's just a policy the department has followed, a 7,000 hour cutoff to take the exam. In recent history, as you heard some of the comments today, the passage rate for the examination ranges between 25 and 30%. So the vast majority of people who sit for the journeyman electrician exam will fail the exam. TSTC proposes to offer an intensive hands-on program consisting of 5 semesters. So it's a 5-semester associate's degree program that includes work in a high-tech laboratory environment and the opportunity to work in the field as part of a cooperative education course. Safety training will be a mandatory part of the curriculum. Under proposed rules, the department will approve a model curriculum for Jeep programs. And each person who wants to offer a Jeep program has to separately apply to us for approval. Under the proposed rules, someone who graduates from the Jeep program will be able to sit immediately for the examination instead of having to wait till they have 7,000 hours of on-the-job training. That measure is designed to increase the examination pass rate. Additionally, the Jeep program graduates under these proposed rules will generally receive a flat 3,000 hours of on-the-job training credit for completing this 2.5-year program. Now, the actual program may or may not be 2.5 years, depending on who's offering it, because TSTC's program is a degree program, also includes some elective courses and general education courses. But it'll roughly be that long, and you'll get a flat 3,000 hours toward on-the-job training. The rules do this by redefining what is on-the-job training to include completion of the Jeep program. The rules also make some changes regarding exam eligibility. Includes a new rule that sets forth the program criteria to offer a Jeep program. The department believes that the measures will increase the exam passage rate without compromising public safety. And the 3,000 hours that this would offer takes into account the amount of effort that one would have to expend to complete this program, along with the intensity and quality of the instruction. These rules were developed on expedited time frame due to TSTC's request and their need to obtain accreditation or approval from the Higher Education Coordinating Board. We published the proposed rules in the Texas Register on April 10th. The 30-day comment period ended just last week on May 11th. We received 39 comments. Various individuals and organizations filed comments. We discussed those comments at the advisory board meeting last week. I've included the summary of the comments along with the feedback we received from the advisory board in your written materials. In response to the comments we received from TSTC, I'm recommending a change to the proposed rules to Rule 73-112E. That rule sets out a requirement about what portion of the training has to be hands-on. The original rule had that 80% had to be hands-on training. TSTC asked to change that because only the technical curriculum would be hands-on. The English and math and other elective and general education courses it should not apply to. I also recommended striking a reference to a floor of 1,480 hours of contact hours based on updated information about how many hours this would take to complete. And also because we intend to specify the contact hours when we propose and when we adopt the model curriculum. In response to other comments that we received, so we received some comments from the governor's office about this. We also received a whole lot of written comments. And one point we wanted to cover was treating people who graduate from registered apprenticeships with parity to people who go to TSTC. So we're also recommending an additional change to Rule 7321 to allow people who graduate from a registered apprenticeship to also sit immediately for the exam. And we plan to separately develop a rules package to also address alternative qualification through registered apprenticeships. I recommend the commission adopt the proposed rules with the changes that I've noted in your written materials. I'm available to answer any questions, and I have Steve Bruno with me who also helped answer questions.
Any questions, Commissioner?
Yes, Chair. Council, is there a resource witness from the TSTC we can talk, or we are not allowed?
Do you have questions?
Yeah, for the TSTC, because I think specifically it says TSTC.
Yes, we have Carla Flanagan and Darren Timmons as resource witness.
Would it be possible to ask them questions, or can we ask questions?
Absolutely.
Okay.
While they're approaching, Mr. Chair, can I?
Yeah.
Mr.
I'm sorry.
Please.
Also, we have Kendall Carrillo, who spoke earlier, as a resource.
You might have to pull up a chair, Mr. Carrillo.
Go ahead, Mr. Butters.
Mr. Bruno, could you give us a brief 30,000-foot view, kind of quickly, of what the changes are? Where are we now? What is the status quo, and what is about to change?
Yes, sir. Steve Bruno, Deputy Executive Director for Licensing and Regulatory Services. The status quo right now is that for one to follow a pathway to an electrician, one first must obtain an apprentice electrician license. It's a $20 license where we perform a background check and No contractor and no one who knows our state laws is going to hire you to do that unless you have an apprentice. If you want to become a journeyman electrician, you earn 8,000 hours of on-the-job training. It's approximately 2,000 a year. It could be more. And we have a policy in place where you're allowed to take that test at 7,000. And then when you finish that 8,000, then you obtain your journeyman license. And to become a master, you would need 4 more thousand hours for a total of 12.
Mhm.
What this program would do is create a program that would be allowable at any school that chose. It's not specific to a school, although the idea
Before we
did
get to
come.
that, can I ask a question real quick?
Yes, sir.
And my understanding is that generally the theoretical knowledge takes place in year one, and then you go out and you get your 8,000 hours. Is that broadly correct?
I believe that we've heard testimony to that, yes, sir. And I believe we've heard that there are other pathways, and it's simply given that experience is it's credit for experience. Experience could be performing 20 different functions. It could be performing the same function 20 different times, for example. And so the difference is that this creates a structured program, and it's that currently, as it's proposed, you get a 3,000 hour credit once you complete that program.
So to make a caricature of it, and this isn't every program like you said, but if you take the theoretical knowledge in year one, and then you go 4 years of apprenticeship, and then you're tested at the end of that 5th year, let's say, on what you learned in year one, you're only going to pass at the rate of maybe 27% of the people that take the test. And that's why they're failing at such a great rate. Now, that's an oversimplification, but I'm trying to draw a picture of what's happening.
Yes, sir.
Correct?
I believe that.
Okay.
You've
Now that's the status quo. So
Mhm.
you're taking a test in year 5 on what you learned in year 1. Broad
Yes.
picture. So what is it we want to do now?
Well, what this proposal would allow is for those things to be happening simultaneously. You're learning and you're working. And you are working in as a non-licensee, but as someone who's been around the regulated industry a long time, what I can only describe as it looks like where you would be if you were out getting paid to do the work. It models that workplace. And what this proposal would do is marry those two things together within a program. If you get through this program and you have 10 hours left and you drop it, you're not eligible for this 3,000 hours at all. You must complete the entirety of the program.
Commissioner, do you have a question for?
Yeah. I'll get to you guys. The one, echoing Commissioner Butler's right there, what we heard was that you do that, whatever it is in year one, the codes, and you done with this, and you move on to the year 4, and the code changes every 3 years. That's what we were told right there. And that's the reason or rational why you have the pass rate of 27% right there, because the one they took in, they're not taking. That's what we heard that in. Commend Commissioner Butler for bringing that one up. To the TSTC, just basic question. You're funded by the state, I assume? The reason is we heard a lot of stuff right there that it shouldn't be making sense or something with the number of hours that with all the paperwork, what we have seen, we are diluting the standards. This is a standard word, what we hear, diluting the standards or something. Are you the educators?
Yes. So we have instructors that are all either master or journeyman electricians on staff. And as far as diluting the standards, we are funded by the state of Texas, and we don't get funded by the state of Texas unless our students get jobs. And so the quality of standard of instruction for all of our programs is the utmost importance to us.
So what happens if electricians are failing because of so-called lack of standards or something? They say, you all are going to get egg on your face. Fair enough?
Correct. Yeah, we will
So
not get funded.
there is a greater responsibility for you all to put what got to be done correctly. Fair enough?
That's correct.
And you're funded by the state, and the coordinating board has to approve, and they look into your performances and so on and so forth. Fair enough?
Correct.
That's correct.
So given this, because I'm a licensed engineer, okay? Why are we treating someone so bad right there? I can't get it right there. We have so many programs, we make them educate, but we don't give them the day they pass out or something there in the program they can take. I took my engineering and license, in training after I graduated because I didn't want to do it first, but that's a choice I made. But today people can take when they're in a bachelor's program. But here we are trying to deny someone the right to do, but you can work also. The practical experience, what it is. It's pretty astounding that we are creating more burden to Texans by coming up with regulation after regulation, whatever it is. So your rationale of 3,000 hours, what was the basis of the 3,000 hours?
Good morning. I'm Carla Flanagan. I'm the Associate Vice Chancellor of Instructional Alignment Innovation at Texas State Technical College. That was the converted because of the proficiency that the students have to demonstrate for the different skill sets. So if they were to gain those 8,000 hours in industry, like Mr. Bruno said, they could be doing it in the same skill over and over again. The 3,000 hours were more conversion because we are teaching all skill levels that the industry has set for the master electrician license.
So can you all make it a little bit better rather than, we heard, why don't you make it 4,000? Someone from industry, can't it be made something 4,000?
Absolutely. We had initially requested that the conversion be 4,000.
Okay.
And I believe it was a communication between our partners at TDLR as well as their advisory committee.
Okay. So the other question I have is, if someone wants to take all this, supposed to be 8,000, there is a choice. They can take the test after 8,000, whatever they want to do, correct?
Absolutely, sir.
But you're giving a chance for them that if you want to take either 3,000 or 4,000 or something, they can do it right today.
Yes,
Or you can wait 8,000. No one is stopping them. Fair enough?
correct. And just to clarify, sir, when they take the exam, all they're doing is taking the exam. They still have to fulfill the remaining 5,000 hours on the job to be issued the license. All we're giving them is the opportunity to be able to meet the standard by passing the exam after they take a program at TSTC.
Well,
Very exciting. Very exciting. Excellent. Any other questions? Wait, Commissioner Garcia.
I was wondering, so what I'm seeing now is high schools are now having some vocational programs. So those students with those hours be part of the hours in high school and then they go to TSTC? And the hours.
I guess what
carried-
she's asking is their dual credit.
I believe if they are a TSTC approved dual credit program, that program is ran and operated by TSTC. So they are TSTC students. The instructors are TSTC instructors. So if they fell under our program, then yes, ma'am, that would count as well.
Right, but there's high schools that are actually teaching some of these vocational programs. And I was just wondering if there was a dual program where their hours from high school are transferred to TSTC. Not that your guys are teaching it, but the high school teachers, just like the dual enrollment for English, et cetera.
For this program specifically, it is all or nothing, I believe is our conversation.
So,
So they have to complete the program in its entirety at TSTC.
Stephen Leary, Assistant General Counsel, if I could just clarify an issue. The Career and Technology Education Program for residential wiremen was a separate thing. And it is offered in the high school level, but it contains a restriction that the hours that you spend learning to be a residential wireman, you can't apply toward a higher license class. So I don't know if that may be what you're, part of what you're asking about.
So I think I can kind of answer your question. I'm sorry to interrupt, and please feel free after I'll do the best I can to kind of explain kind of what's going on. So the average age of an electrician in the state of Texas is 57 years old. Okay, that's my age. I do not want to be climbing around in an attic at this weight and age. Okay, so we have to do something. The demand is so massive. Quit laughing. The demand is so massive for electricians that something has had to happen. So we as an agency have to be responsive to what Texas needs today. And what Texas needs today is a wholesale look at the way we license vocational people. What we're doing today and what this commission has done in the last year with the pilot program at different community colleges to make the final exam, the licensing exam, is putting people to work so much faster. So this will go eventually as other colleges. This is the state college here. Texas State Technical College is the state's official college. They'll have their own program. But there are other programs like Austin Community College could create their own program where they will have dual credit. What we're about to see, what we're doing today, and what we have been doing for the last year, the agency needs to be aware and the public needs to be aware. We are changing the way vocational licenses are going to be issued in Texas. We're taking a page back in time to thousands of years ago, 2,000 years ago, where people would apprentice. That's really what we're talking about, is apprenticeship in high school. So when they graduate high school, they may have 2 years of community college credit, and they may need just a little more, another couple of years, to be an electrician by the age of 20 and go out and make $150,000 as a high school graduate with 2 years of community college. That's what we're doing. We're taking a page back. We're stepping back into history and saying we're creating apprentices. And that's going to change the face of Texas. I'd like to see that happen in every license program that's available at a community college level. That's what everybody wants to go to college. College is not for everybody. You can make twice what a college graduate makes as an electrician today in Texas. You can make $150,000, $200,000 as a 22-year-old kid. So that's what we're talking about. Yes, you can.
Hit your mic. Thank you.
My concern is this is when we lose our students right out of high school. So if we can't get them to perhaps go to, technical college and or be able to get a job right after high school, this is when we lose them. This is when we lose them. And so I'm from the Valley. We're going to have a lot of action going on with the Port of Brownsville. We are just going to be overwhelmed if we think we need electricians and welders and all that good stuff now. It's going to be worse. And so I was just at one time wondering if there was any way that they can graduate from high school, get licensed in one of the vocational programs so they can start a job, because most kids down there, and I can only speak, I taught for a little bit, if they don't have something to go to, they need immediate money, or else they drop out of school, they get on the system. And so my concern was always, if they're going to take this in high school, what do they get for taking it in high school? Just a little more knowledge till they get to TSTC?
So I think you heard the commissioner's heart on this, right? We're progressing towards this model. This is where we're going. It is a process, and I think you've heard it, Mr. Bruno. You've chaired this up, and we're
That's
trying
right.
very difficult. And there is a lot of opportunity here. This is just the beginning of the conversation, and it will launch even further. I know the responsibility that you guys are taking from the higher education system. We want to partner with that. So this will be a conversation we evolve in as a commission. You've heard the heart. So is there any other questions?
I do have
about the regulation.
Yes, I do have. I understand that the advisory board met on May 12th, and there was a difference of opinion. Can you all elaborate what happened?
I can. The majority of the board was not in favor of the rule packet. There was a vote that was taken to reduce it to 2,000 hours. And when they did that, the vote was 3-4 against that. So there were concern among several of the advisory board members about shortcutting, what they perceived as shortcutting the on-the-job training requirements of the act, and about how that might jeopardize public safety. And there was concerns that the work that's done in TSTC's program or similar program might not track real-world conditions. So those were concerns that the board addressed. They matched the same concerns that they were filed by the many commenters who were against the proposal. Matched some of the very concerns you heard today, and that was the majority of the board seemed to feel that way.
Council, given the fact right there, typically advisory board is just advising. Under chapter 51, what's the recourse we have? Can you read it to me?
Yes, Commissioner Derek Burkhalter, Assistant General Counsel. So under both Chapter 51, which is our enabling statute, and Chapter 1305, which is the electrician statute, The advisory board only acts in an advisory capacity, so their recommendation is not a prerequisite to adopt rules for electricians.
We have no obligation to. Follow.
Okay, thank you.
Thank you.
One more last question. You all mentioned this DSTC. You all mentioned that it was 3,000, but what changed it to 4,000 right there? Again, it's, I'm sorry, it was supposed rational why it got changed to.
I think that was just kind of conversations. If you heard the opposition to the program, and so it was kind of a compromise to meet some of the concerns from the advisory board.
I don't compromise on kids' future. Chair.
All right. Anything else? I'll take a motion.
Chair, I have a motion to adopt the rule with 4,000 hours as a credit.
You're modifying it.
That's
from
correct.
3 to 4. Okay.
That's
Is there a
correct.
second to that?
I'll second that.
All right. All in favor, say aye.
Aye.
All opposed? All right. Motion carries.
And just to clarify, Mr. Chairman, would that be also with the other recommended changes?
Yes. Yes. It's all packaged in, except for the modification to the 3 to 4. Okay.
Thank you.
Thank you all.
Okay. Going to next item, Mr. Burkhalter. Item K. All right, Mr. Burkhalter.
Okay. Thank you, Commissioners. Again, Derek Burkhalter, Assistant General Counsel for TDLR. For this agenda item, for your consideration are the proposed rules for Chapter 97, which relate to the motor fuel metering and quality program. These rules implement recent statutory changes from Senate Bill 246, Senate Bill 2371, and House Bill 4690, which amended state law relating to motor fuel quality standards, testing procedures, stop sale orders, and skimmer reporting requirements. In summary, the proposed rules do 4 main things. First, they update the department's statutory authority and definitions, including references to the Financial Crimes Intelligence Center and recently enacted provisions related to skimmers and electronic terminals. Second, they adopt required national standards by reference, including applicable ASTM standards, which is the American Society for Testing and Materials. That's for motor fuel quality, and NIST standards, which is National Institute of Standards and Technology. Those standards are for device specifications and tolerances. So this aligns our Chapter 97 rules with the statutory changes made by House Bill 4690. Third, the rules clarify skimmer-related requirements. They make clear that the existing skimmer reporting and removal provisions apply to skimmers found on or in motor fuel metering devices, and they add reporting requirements for service technicians or service companies that discover skimmers on electronic terminals. Finally, the rules establish procedures related to stop sale orders, including appeal and remediation provisions, and clarify the factors the department may consider when lifting a stop sale order. So these proposed rules were published in the Texas Register on February 13th, and the public comment period closed March 16th. The department received comments from one interested party, the Texas Food and Fuel Association. After reviewing the comment, the department declined to recommend changes, and the advisory board met on April 8th and recommended adoption of the rules as published. And so staff recommends the commission adopt these rules as published with an effective date of July 1st. And I'm available for any questions.
Any questions, Commissioners? I'll take a motion.
Chair, so move to adopt the rules with effective date of July 1st, 2026.
Is there a second?
Second.
All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you, Mr. Burkhalter.
Thank you.
Mr. Funderburg. Item L. You know what? Okay. Hey, you know what, Mr. Funderburg, won't you stand by? I'm good with 11:46. We'll come back here at 11:50. All right? Take a break. to order, Mr. Funderburg. Please note, Deanne, that Dr. Weston had to leave.
Okay.
So down to 5. All right. Funderburg, go ahead.
Good morning, Chairman, Commissioners. I'm Christopher Funderburg, Assistant General Counsel. Item L consists of amendments to the rules governing laser hair removal. The adopted rules are necessary to implement Senate Bill 748, passed during the 89th legislative session in 2025. The adopted rules remove size and font requirements from the mandatory warning signs and also remove requirements that the signs include verbiage about the hazards of electromagnetic radiation. The adopted rules also clarify that an applicant for an apprentice in training certification must submit proof of successful completion of a training program approved by the department covering certain required training topics. Finally, the adopted rules amend a consistent grammatical error by changing all references from a LHR facility to an LHR facility. Proposed rules plain talk summary was published on February 19, 2026. The rules were published on March 6, and the public comment period closed on April 6th. Department received one comment submitted by an individual in favor of the proposed rules. The comment requested that the postings, quote, remain visible, indicating the potential risk. This commentator also requested that individuals performing laser hair removal be licensed and certified in the state in which those individuals perform procedures. While the department appreciates the comment support, the department observes that it is not clear which section of the rule package the comment refers to regarding postings, as this term does not appear in the proposed rules. Also, all individuals performing laser hair removal procedures in the state of Texas must be licensed and certified, subject to certain specific exceptions. Thus, the department did not make any changes in response to this comment. I recommend that the commission approve the proposed rules with effective date of July 1st, 2026, and am available to answer any questions.
Any questions?
Yes, Chair. Has what is it? The advisory board?
Oh, there is no advisory board for the laser hair removal.
Okay, thank you.
All right, taking a motion.
So move to adopt the rules with July 1st as effective day.
There's a second. All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you, Mr.
Thank you.
Mr. Neal. Item M, Commissioners.
Morning, Mr. Chairman, Commissioners. Glenn Neal, Transition Director. I'm joined today by Caroline Espinosa, Director of Strategic Communications. We're going to present a very high-level overview of the 2027-2031 Agency Strategic Plan and ask for your approval of the draft document, which is due June 1st, 2026. Before we get started, I'd like to offer Vice Chair Butler an opportunity to say a few words about the Strategic Plan Work Group, and they participated in the drafting of the plan.
Sure you want to do that? Go ahead, Mr. President.
Mr. Neal, thank you so much. Thank you for all the work. I'm just messing with you. All right. So, Mr. Neal, thank you so much for all the work that y'all have done on the strategic planning process. It's an incredible amount of work, and I think we've got a wonderful product.
Espinosa, too.
Miss Espinosa, of course. I hadn't gotten there yet, but okay. The Strategic Planning Commission Work Group first met on April 14th to discuss the draft agency goals and actions for the 5-year plan horizon. Staff worked with us to refine the list, and we settled on 5 goals that staff will lay out later in today's meeting. We met again on May 14th and focused on redundancies and impediments, and on a new requirement from the LLB proposing realignments, deregulations, or transfers of programs that do not align with the agency's core mission. Staff will provide more details on the approach for this requirement. Throughout, the staff have adhered to the strategic planning guidelines and have taken a best of both approach to combining the legacy Texas Lottery Commission plan format with that of the TDLR. Overall, I think you'll find the plan reflects the consensus goal setting and honest assessment of challenges that form a valuable blueprint for the upcoming 5-year period. Mr. Neal and Ms. Espinosa.
Thank you, Vice Chair Butler. As Vice Chair Butler mentioned, goals and actions were one of the primary focuses of the plan, and really that's where the action is for the strategic plan. So I'm going to go through the 5 goals that were ultimately selected for inclusion Goal 1, remove barriers and identify innovations in licensing and regulation to improve outcomes and efficiencies. Goal 2, continue to integrate all functions of the Texas Lottery and charitable bingo programs at TDLR. Goal 3, define and implement TDLR 3.0 to strengthen TDLR's ability to efficiently, effectively, and responsibly manage its current and future operational responsibilities while ensuring the resources, structure, and processes necessary to carry out its mission successfully. Goal 4, continue efforts to combat human trafficking and protect the public within TDLR regulated industries. And finally, Goal 5, support the continued expansion of the Financial Crimes Intelligence Center and strengthen their efforts to combat skimmers, card fraud, fuel theft, and financial crimes in Texas. The plan includes specific action items to achieve each of those goals and describes how each goal meets the governor's 5 statewide objectives, which broadly speaking are accountability, efficiency, effectiveness, customer focus, and transparency. The redundancies and impediments exercise that we went through generated a lot of great ideas, and Ms. Espinosa is going to walk you through the high points of our approach there.
Good morning, Commissioners. So as part of the strategic planning process, we are required to identify statutory, regulatory, and operational redundancies and impediments. And this year, a new requirement related to regulatory efficiency and burden reduction was added, and that is the one that Chairman Butler was referring to earlier. As we went through this process, we gathered feedback internally and externally throughout TDLR's strategic planning process from program staff, licensees and stakeholders, Commission and Advisory Board work groups, and executive leadership. Staff also analyzed licensing data to identify programs with low or declining populations, low complaint volume, outdated regulations, or duplicative regulation. Many of the items identified were informed by recommendations and observations from the Sunset Advisory Commission process and the Texas Regulatory Efficiency Office, or TRIO review. In some cases, recommendations reflect opportunities to streamline processes or better align resources and responsibilities. In other cases, items were included because additional resources are needed to regulate certain industries effectively. And this process provided us an opportunity to identify those needs candidly and transparently. Overall, the recommendations are intended to provide legislators with a practical assessment of where efficiencies can be gained, where modernizations may be appropriate, and where additional resources may be needed as TDLR continues to grow and evolve. With that, I'll turn it back over to Glenn.
Thank you. So Section 2 of the plan includes several supplemental schedules that are required by the Legislative Budget Board. Perhaps most importantly, the agency makes suggested changes to its budget structure and performance measures. As of today, we're still awaiting LBB approval of our suggested changes. In your draft plan in your packet, you have a red line marked up version of that, which of course is subject to change. The agency recommends new strategies under Goal B, enforcement. The first is combating human trafficking, and the second is combating financial crime. Those are new strategies under that existing goal. At the request of the Legislative Budget Board, the agency eliminates Goal E, which is enforce bingo laws, and instead creates new strategies for charitable bingo under Goal A, licensing, and Goal B, enforcement, for better alignment with TDLR's predominant budget structure. And I think at a very high level, we'll talk briefly about customer service, which is another schedule, and then we'll wrap it up.
Thank you, Glenn. So because this reporting period covered mostly a time before TDLR and the Texas Lottery were a single agency, this strategic plan has separate customer service reports. For the future strategic plans, however, this will be consolidated into a single report for the unified agency. To gather public input, TDLR held 3 in-person public meetings in Dallas, Houston, and San Antonio, as well as 1 virtual statewide session. We also gathered feedback through our social media platforms. For the TDLR survey, it was sent to staff as well as to more than 1 million email subscribers, and we received over 4,000 responses. On the lottery side, retailer surveys were sent to over 8,000 retailer contacts with over 1,000 responses received. Overall, the feedback was positive. Respondents expressed strong satisfaction with staff professionalism, customer service, and online resources. Common themes for improvement included reducing wait times, improving access to subject matter experts, and continuing to modernize systems and digital services. This concludes our overview of the strategic plan, and we're happy to answer any questions you may have.
Any questions?
Yes, sir. I want to commend the staff and Courtney, the Executive Director Arbor, for working with us on the work group. Couple of questions, Mr. Neal and Ms. Espinosa. We talk about TDLR 1, 2, 3 or something. I would request that it's only TDLR, no 1, 2, 3, because I think, statute doesn't say that we are divided into whatever it is we can call internally, but let's not confuse the public that TDLR is TDLR. If you want to change some verbiage or something to fit in the pre-post, whatever it is, you can use it, but let's not go into one. Why did we change 1? Is there something wrong with them? 1 or 2 is something better than 3 or something. Let's not give that one. It's one entity, TDLR. And the other one is of real concern. I think this goes into the licensing exams. At one of the public meetings in Houston where I was in attendance, it was brought to my attention. I think this again to Mr. Bruno's group right there on your testing. Apparently some students have to drive all the way from Houston to San Antonio, and their tests got canceled or something, and they were asked to pay again second time. So this is something concern. Maybe on the strategic plan, we need to look at into trying to see how we can implement measures which would lessen the burden on the licensees and make something pretty effective. And the other one I think Chair and the commissioners, we're big, 254 counties, and we are basically in Austin, Texas. I think we need to start planning to see recruitment is an issue. I think we need to look at satellite offices. I know we have people working in other parts of the state right there. That's a state's issue right there, that we need to have something as satellite offices where people would be working. And if they have any issues, they can go right to the locally rather than driving all the way to Austin right here. So I think something on those lines, I want you all to look into it to see. Yes. We don't make a decision. The folks in the dome make a decision whether they want to fund or not. That's one question. And lastly, I think I did hear we have to have efficiencies right there. Constantly, we do this ALJ hearings, whatever we got to do, the contested cases. Sometimes we do have folks who have criminal conviction. So the court has done that, then the SO has done that. That's strike 2, strike 3, they come here. So we have to have efficiencies right there. The court automatically, whatever they do, those kind of convictions should inform that their license is over, rather than duplicating all the efforts right there, I think, which is inefficient right there. So I understand something on those lines, some verbiage was put in. Is that fair assessment?
Yes, sir, we are working on that.
Oh, thank you. Okay. I'll close my mouth.
Yes, and as to the testing concern, we do have an action item under Goal 1, which removes barriers to licensing and innovation, which is to examine industry-specific testing approaches to determine the most secure and accessible methods for administering exams for regulated programs. So we are going to be looking at that.
And can you read for the record on the human trafficking what we're trying to do right there? I think there's a pretty significant issue, just the overall, couple of points.
Well, okay, sure. So at the goal level, continue efforts to combat human trafficking and protect the public within TDLR regulated industries. The specific actions that we've identified, number 1, clarify anti-human trafficking efforts as an agency strategy and clearly identify resources dedicated to protecting licensees and individuals receiving services from regulated industries, and add tracking and performance measures to assess outcomes, enforcement activity, and impact on public protection. And number 2, establish a restitution fund to support payment for specific third-party services that directly assist victims of human trafficking.
Okay. I think the second one, Chair, I think Commissioner Butler, you want to add something on the...
Sure. Essentially, the reason that idea came up was the agency and every agency in the state of Texas that stumbles across human trafficking is struggling to get their arms around the problem. And so we were trying to do there, and it was just a discussion item at the time. I was just surprised that it made it in the strategic plan. I'm glad it did. It's important. It's vital. And so the idea was to seek some help when we do find true victims of human trafficking. And maybe that's counseling. Maybe that's a place to live. Maybe that's food. Some of these people work for food, as grotesque as that is, but they're in need and they may be in dire need. And so the restitution fund was, if we can, the funding mechanism is yet to be worked out, but the need is there regardless of what the funding mechanism is. And it's just a way of feeding and clothing these victims of human trafficking. And so that's what the purpose of it was.
I think more importantly, I think we need to look at it. The business owners made money and they run off. I think, that probably, I think, let the legislature figure out. And one last thing, I understand that we need more programs or something, that we went through it. We are letting them know that some of those programs could be deregulated. Is that something we have, maybe, 4 or 5 programs? We are looking at trying to suggest that if you all want to do it, go ahead.
Yes, the new instructions included that portion, and so we did outline that in redundancies and impediments. And for some of those programs, it is identifying the need for additional resources, and then for other programs, it's deregulation.
So we are looking at that too.
Okay. Let's do little comments, feedbacks. Everybody's got some, so we're good. This is great. It's always living, breathing, and oversight, not operation. That's what our job. So I want to make sure you guys get the freedom you need. Do what you got to do.
Mr. Chair, can I address one issue that they discussed real quickly? Was you mentioned that you wanted to look at impediments to licensure, and I think the licensing is one, right? Sometimes we need to take a holistic look at what we're doing, and sometimes you look at the minutia, right? Because you could have problems in both, right? The electricians thing, we looked at the holistics. The pilot program with cosmetology and giving them their license, as they take the final exam as a licensing exam. That's kind of a tactile thing, but it is kind of a little bit holistic too. And so when you start looking at these, this is what TDLR is so good at, and has always been so good at. What is the impediment? And for us, we're just administering an agency. But for the people on the ground, they have to wait 2 or 3 weeks to get a test, right? To schedule a test. So let's look at how can we do that? What are the speed bumps that are keeping Texans from getting to work? We have all of these wonderful universities and colleges. Their whole job is to create tests to graduate kids. They can create a test for us, right? And maybe if you go to San Jack, maybe Lone Star Colleges is the one that administers the test. So there's some arm's length a transaction taking place, maybe vice versa. So please look at these things in the future and think about it, and don't be afraid to slaughter the sacred cow. Go after the sacred cow first, the thing that's untouchable, the boogeyman. The way to not be afraid of the boogeyman is go into the forest. Say, where are you? Let's do it. Let's slaughter the sacred cow. So,
okay. Thank you for your time on this. We need a motion, but remember, there's work groups that we have assigned as commissioners. This is where the process gets done. And that's where we wanted to push the process, not in this bigger conversation. But I'll take a motion.
So moved on the draft what we see with what is that word? There's a council that unsubstantive changes or something. Is that what the word you all use?
Non-substantive.
That's whatever it is. Yeah.
A second. All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you. Ms. Wiggins. Do any of you commissioners have a work group report? I don't. Yeah.
yes, sir.
You do? You have one. Got it. Yeah, you do. All right. Go ahead, Ms. Williams.
Good morning, Commissioners. Can you hear me okay?
Yes.
Okay. First of all, just for the record, my name is Liz Wiggins, and I have the honor to serve as the director of an amazing team, also known as the Anti-Human Trafficking Division. For any of you who have talked with me, you know I can talk at length about this topic, and I want you all not to worry. I have it all written down, and I'm going to stay on track, okay? So first of all, I do want to point out that the the Human Trafficking Division is also known as AHT or OT Division. So as I go through, I'm going to refer to it often as the OT Division. Since its inception, the OT Division has really grown from something we were still developing into a more coordinated and proactive model. One that's focused on earlier intervention, stronger enforcement, and using our resources more strategically. Instead of reacting after the fact, we've worked to identify trafficking activity earlier, strengthening our prevention efforts, and building a more connected response across the agency and with our external partners. The one-pager in front of you, which should be pretty big, it should have some data at the bottom there. It highlights some of that work and provides a snapshot of where the division is today. As you'll see, the division was formally established on March 1st of last year, bringing together inspections, prevention-focused initiatives, and legal enforcement into a more unified model. You'll also see the impact of the coordinated approach reflected in that data at the bottom of that page. In our first year, we issued 48 emergency orders that were tied to concerns involving human trafficking, sexual assault behavior, and diploma middle schools. We revoked 100 massage therapy licenses connected to illicit operations, and we closed 3 diploma middle schools that were exploiting students. We actually closed a 4th school in March of 2026, and combined, the closure of those 4 schools impacted over 5,100 students. The one-pager also highlights the preventative side of this work. We hosted or presented 55 human trafficking-related trainings to both internal and external audiences. We launched 3 community impact projects focused on high-risk areas, and we expanded our on-site victim assistance partnerships with 24 NGOs. That's to strengthen our victim support and collaboration efforts. And as you'll note, 24 NGOs is not nearly enough for 254 counties in Texas, but we are working to grow that number. You may have seen the Houston Chronicle, written by Eric Dexheimer earlier this month. It was an investigative piece examining human trafficking in the massage industry in Texas. And it highlighted several of the partnerships that we have been building. Internally, we have made significant progress through the partnerships between the OT Division and field inspections. They actually have 8 designated anti-trafficking inspectors. Those inspectors help ensure that our strategic, data-driven, and aligned with the OT Division's priorities. Just as importantly, this work reflects strong collaboration across the agency. In addition to field inspections, we actually rely heavily on several other divisions, including enforcement, E&E, and licensing. Their support has been critical to everything that we've accomplished that I've spoken about today. I also want to recognize Courtney and Susanna for their leadership, their guidance, and I want to give a big special thank you to Amanda Jones, who has been behind the scenes supporting our team and helping us have the tools that we need to do this work that I've talked about. As we look ahead, the OT Division is focused on continuing to strengthen our systems, expand our partnerships, and build a long-term framework that protects communities and protects the integrity of our regulated industries. And this is my gift to you all, that I stayed on point. You're welcome. Thank you.
Well done. Thank you, Ms. Wiggins. I appreciate it. I had the privilege of going to the White House with the drug czar. This is a big deal. I got Courtney connected with that office. So the fentanyl and the human trafficking are going to be their focus. So we look forward to that.
Thank you so much.
Thank you, Ms. Wiggins.
Again, I'm very honored. Thank you.
Okay. Commission reports. That's you.
Got it? Okay. Mr. Chairman, the Audit and Finance Commission Work Group. Earlier, I failed to mention that on the Strategic Planning LAR Commission Work Group, Commissioner Drockstrom and Commissioner High also serve on that work group and are instrumental in making sure that we stay on point and helping develop a good product. So thank you, both commissioners. On the Audit Finance Commission Work Group, I have the pleasure of serving with Commissioner Castaneda and Commissioner Wesson. The Audit and Finance Commission Work Group met on Wednesday, April 29th, 2026, and staff presented the audit tracking tools and dashboards regarding open findings and opportunities for improvement from previous fiscal years for both licensing and regulation and lottery and bingo. The policy research and fiscal analysts have continued quarterly check-ins with staff responsible for implementation of audit recommendations and opportunities for improvement. All open findings are progressing as anticipated. The findings and opportunities from the State Auditor's Office in the Licensing and Regulation Enforcement Audit have been included in this quarter's materials. A new status has been included on the dashboards. It will be used to reflect when staff have completed remediation activities on a finding, but the auditor has not yet finished their review and determination regarding full remediation of the finding. And that's my report on the Audit and Finance Commission Work Group, Mr. Chair.
Thank you.
Do you want?
No, I'm good. Oh, you want the next one? Go ahead. Yes, go ahead.
Yes, sir. And this is on behalf of Commissioner Wesson. The Enforcement Commission Work Group is chaired by Commissioner Wesson. I happen to serve on it as well as Commissioner Droxaram. The Enforcement Commission Work Group met on April 7th and May 5th to discuss recommendations for process improvements in the Licensing and Regulation Enforcement Division. The work group also reviewed the tabled item from February 18th Commission meeting relating to granting continuances for contested cases and motions for rehearing. And that's my report, Mr. Chair.
Thank you. All right. Any other commissioners have reports? Okay. Ms. Espinosa.
Back again?
Did you hit the button? I don't know if it.
Oh, there we are. Sorry about that.
You're good.
So we are recommending 5 new appointments, 1 reappointment, and 1 reappointment as presiding officer for your consideration and approval. For the Combative Sports Advisory Board, we recommend Michael Busey of Arlington to fill the position of MMA promoter. Mr. Busey is a promoter for Extreme Knockout and Back Alley Promotions and has held over 100 amateur and professional events in Texas. This term would expire May 20th, 2032. For the Licensed Breeders Advisory Board, we recommend Danielle Kessler of Round Rock to fill the position of Animal Control Officer. Ms. Kessler has served as the Animal Control Supervisor for the Round Rock Police Department for the past 8 years and is a member of the Williamson County Regional Animal Shelter Advisory Board. This is a partial term that expires on February 1st, 2029. We also recommend Kelly Marshall of Nacogdoches to fill the position of licensed breeder. Ms. Marshall is a retired agriculture teacher of 31 years who currently owns and operates her own business. This term would expire on May 20th, 2032. For the Lottery Advisory Committee, we recommend Bobby Warren of Dallas to fill one of the positions of a representative of a divergent viewpoint of the lottery and lottery operations. Mr. Warren is the Director of Fuel Sales and Environmental Compliance for Fuel City and has served for 10 years on the Texas Food and Fuel Association Board of Directors. This appointment would provide a quorum for the Lottery Advisory Committee. Staggered terms will be recommended for adoption once the remaining seats are filled. For the Texas Tax Professional Advisory Board, we recommend Monica Turner of Dallas to fill the position of public member. Ms. Turner has served as a Dallas County election judge since 2008 and currently owns and operates her own business. This term would expire on May 20th, 2032. For the Dyslexia Therapists and Practitioners Advisory Board, we recommend the appointment of Susan Pattison of Lockhart for the position of dyslexia therapist. She has been a certified academic language therapist since 1996 and has more than 32 years of experience in the field of dyslexia. This term would expire on May 20th, 2032. For the presiding officer of the Speech Language Pathologists and Audiologists Advisory Board, we recommend the reappointment of Sherry Sensibrian of Lubbock as the presiding officer of the Speech Language Pathologists and Audiologists Advisory Board. Ms. Sensibrian has been licensed as a speech language pathologist since 1984 and is currently a professor and the Executive Associate Dean at Texas Tech University Health Services Center. This term would expire on May 20th, 2028. Commissioners, one additional item. In order for the Lottery Advisory Committee to begin meeting prior to the July Commission meeting, staff would like to request consideration of appointing Kim Kiplin as acting presiding officer of the committee. This would be a temporary designation should the Lottery Advisory Committee wish to meet prior to the July Commission meeting. A formal presiding officer designation will be recommended by staff at the July meeting. At this time, would the commission like to consider that temporary appointment along with all of the others?
Yes. All right. Any questions? We have the lottery we have some vacant. How many do we have the lottery 3 left?
After this, it would be 4 left.
4 left. So any recommendations would be greatly warranted through the specifics for that qualification. So we want to make sure, and is any feedback, let Ms. Espinosa know. Okay. We can get them to you. We'll get them to you.
And we do have a couple more candidates in the pipeline. They just need to complete some of the required items.
All right. I'll take a motion.
So moved.
There's a second.
Second.
All in favor, say aye.
Aye.
Opposed? Motion carries. Thank you,
Thank
Mr.
you.
Fernando. Okay, executive reports, Courtney?
Chairman, we're going to table most of the executive reports until the next meeting, but there's one update I want to provide because we can't not discuss it. On the 11th of this month, we launched the core licensing system to 2 of our licensee groups, weather modification and behavior analysts. After many, many months of work, the innovations work group working to give input on this. We brought industry in a demo prior to launch, and we've had very good feedback from members of that industry. We started with 2 smaller programs, but this becomes the foundation of the larger programs that make its way into core over the next several months. I'm mentioning it as a thank you to the staff who have put in countless hours, weekends, nights, and days in addition to their day jobs. Steve Bruno as executive sponsor, who's really been helping to lead the way. Steph Bache, our primary project manager. John Fowler, our CIO, has obviously been very involved, but a number of staff. We'll also go into the 90th session asking for authority to continue spending from this budget so that we can continue to implement. So this will continue to be the largest technology project we've ever undertaken as an agency, and one that will continue for several months, but it's gone very well. I'll tell you, we have 330 registered users so far, 233 applications received, and 189 already issued, which is a testament to the licensing team and how quickly they're turning these around under the new system.
Sounding. Great job. Great job. All right, Commissioners, item R, 28th of July will be our next meeting here. We're going to get a feedback on the October move. So as soon as I hear back from the rest of the commissioners, we'll go with that. But and we also confirming the December 8th meeting. So anything else? All right, take a motion to adjourn. Just a second.
Second.
All in favor, say aye. Opposed? All right, carries. Good job.